a moment. Good morning, everyone. Yes, can we just determine the structure as to how we're going to do it?
Is that the structure of my address? That you
Yeah.
Okay.
Because I can see that the heads of argument I received from the state yesterday.
I comprise of 48 pages.
Yeah. No. It didn't have the timeline, and it didn't have the mind map.
Yes. My Lord, if I may.
So who's going to do what?
No, my Lord, I will be dealing with the address in this matter. I will be doing it at the hands of my heads of argument. Firstly, we will just, as it is set out, deal with the introduction and legal concepts, all the legal principles that's applicable, especially with focus on the trafficking in persons. And then I will not be going through the summary of the evidence, which I submit, my Lord, is detailed enough in the heads of argument. We will then be going to the timeline, and the timeline as an additional aid electronically. We will go through the timeline as it is, and then thereafter I will deal with the corroboration for Ms. Lombard's evidence as is contained in the heads of argument, and also on the mind map. So the mind map is just an add-on additional to the heads of argument, whereafter I will then come to the inferences sought to be drawn, and then the prayer in this matter for conviction. My Lord, so that is how I intend to deal with the heads of argument. If that is suitable to my Lord, then I wish to proceed in
That's
that manner.
fine. Did you provide an electronic copy of the mind map to my registrar?
Yes, my Lord.
Has it been uploaded? Not yet? You just received it now? Yeah. As soon as you can upload it, I can open it up over here, because this is not going to help me.
Yes, my Lord, it is. I apologize. It's very small. I have the same problem, so I'm also...
No, I thought I was going to get it yesterday afternoon, because I've arranged for Ms. Naidu Chetty to print me a big one at the office before they came through. But unfortunately, it only came this morning. Before you start, maybe your colleague and the others, you referred me to a number of cases in the heads of argument. You missed one very important one. You referred me to the Busa case inter alia.
Yes.
You referred me to other cases on circumstantial evidence.
Yes.
I am going to ask you about State versus Reddy. It was 2016 SCA, but you don't have to go there immediately. But you've also missed out the case because it's unreported. But it's the matter of State versus Kumani. It's on Safely as Kumani, K-O-M-A-N-E versus S. In brackets, round brackets, 51-2019, square brackets, 2022, ZASCA 55, delivered on the 20th of April 2022. And in that particular matter, a reference is made to all the cases that's relevant, including Reddy, including Lubaka, including everything that went before it, and also deals with the right to remain silent as set out in Busak, in the Constitutional Court judgment, more particularly paragraph 23 of that judgment. So just have it ready, if not in argument in chief. I am going to ask you to take me through it. Similarly, I'm going to ask the defense to take me through it because it actually answers a lot of questions.
Thank you, my lord, and I'm indebted to the court. Thank you, and please, I will request to have the opportunity to study the judgment and then address you on it, if you will allow me.
Yeah, even in reply, in the morning, but I want the parties to be aware of it, that it's one of the cases.
Thank you, my lord.
That I've looked at and was not mentioned in the heads and was not mentioned in the cases provided by Mr. Harmse and Mr. Sievenerijn. And then just for housekeeping, the process I'm going to follow is that I might not look at you. Doesn't mean I'm not listening to what you say. To my right over here, I have all the authorities that we will refer to, and I can open it up on the screen over there. I also have your heads of argument, and I have all the cases that Mr. Harmse and Mr. Sievenerijn brought to our attention last night. I also have the electronic evidence available for everything that we've dealt with. So if you want to refer me specifically and we're unsure, I will just refer to
Thank you, my lord.
My devices that we've set up.
Thank you, my lord.
Thank you.
Thank you, my lord. If I then may start.
Certainly.
By way of introduction, my lord, this is indeed in South Africa a first case of its kind to be decided on this specific set of facts. And I base that on the fact that for all of the research that has been done, and more specifically the latest article by Dr. Beatrice Creer that I have referred the court to and also attached as an authority, a comprehensive study was done of all of the cases that has been dealt with in South Africa, and this is the first one of its kind. And I say that because usually in a tip case, and I will refer to trafficking in persons further as a tip case, usually in a tip case, the main source of information and your most important
Can I just check something? Mr. Paulus, will you be able to follow the English argument? Oh, the interpreter is there. But if you, she's going to just give you a summary in Afrikaans, but do you understand English? Good. Mr. Van Rijn, understand? Smith? Just so that we don't miss anything. And I'm not going to have the argument translated into Afrikaans out loud. And we're going to deal similarly with the judgment. Good. Yes, thank you.
Thank you, my lord. I was saying that usually in a tip case, the most important witness and most important source of information usually is your victim. In this case, we don't have a victim because our victim, little Joshlin, is still missing. That in itself does not make that unique.
We have a victim, but the victim's voice is not heard in open court.
Indeed, my lord. The victim can also not explain exactly what happened to her, as usually we do have. In this instance, my lord, in all of the other previous cases, and I've referred the court to those cases not to say that they are authorities and binding to the court, not at all. The purpose of actually referring the court to those cases, the Loubser and the Kutse matter, that's in the High Court in Pretoria, and then also the Zama Madladla matter from KZN. My lord, in those cases, all of them, where the child was sold, it was actually a trap or undercover operation in terms of Section 252A. So in other words, the harm was stopped, and actually the child was never handed over, or if handed over, immediately then seized. So there was a police agent involved. In this instance, we don't have the victim, and that is why it is seen as a first on that basis. So my argument is, and no pressure, my lord, but this is a very important case also for jurisprudence for South Africa. When we look at the crime of trafficking in persons, it indeed is a very heinous crime. My lord, it is often referred to as modern-day slavery, and that is in essence what it is. It is the commodification of a human being, commodification of a person, for the purpose of exploitation. My lord, in this instance, we are saying that our victim was sold, and that is our case, and that was a planned agreement between the accused. So, my lord, contrary to normal belief, one would not want to say that one can value or put a value to a person or a person's life. When we're dealing with a hit murder, then the murderer is paid to commit the crime of murder. But in trafficking in persons, we're actually placing a value on the person itself. And that is why it is seen as such a terrible crime. A person is never supposed to be a commodity. And for that reason, there is no offense in common law or in statutory law that prescribes that the selling of a person is a crime. So that was a lacuna. And that is exactly why the legislature then, and in following the international obligations, more specifically the Palermo Protocol, the legislature then enacted this specific piece of legislation so that we can deal with that. For the reasonable person on the street, it would sound bizarre to think that a person can be sold, more specifically that a child can be sold. But unfortunately, we see in the cases that it happens, and therefore there was a need for this legislation. My lord, if I then go to legal concepts in my heads of argument, more specifically to the offence of trafficking in persons, which the definition in South Africa is found in Section 4.1 of the Pakotip Act, then we look at the elements of the offence. Now, my lord, it is so that all international standards and following the Palermo Protocol, as I have referred to earlier, my lord, our legislation follows that, and it's accepted that for trafficking in persons, we have three elements. The first element being the conduct or the act. In other words, what exactly was done. The second one being the means, how it was done. And the third one being the purpose of exploitation. My lord, it's important to remember that in South Africa, or in our legislation, if you look at section 4.1, it doesn't specifically say that the elements itself is only applicable to a child or an adult victim if you only look at section 4. But you need to look at section 11 as well. So I deal with section 11 in point 2.1.2 of my heads of argument. And if one reads section 11, then it is my understanding, and this has successfully been argued, my Lord, that when we're dealing with a child victim, then there are only the two elements. Section 11 precludes the means as an element. My Lord, and I respectfully referred the court to two cases in this regard. The Ngasana matter, my Lord, that was Becky Ngasana and two others. Although it's an unreported decision, my Lord, it was a case that I prosecuted in front of Judge Joshlin, who's now a judge in the Supreme Court of Appeals. And my Lord, he deals with all of the concepts, international obligations, and also the understanding. And I specifically, my Lord, refer the court to
yes. It's
on page 51.
It's a transcribed judgment, so it doesn't have paragraph numbers.
Yes, my Lord. But that is the signed judgment.
No, that's fine. And it's
on
unreported.
Page 51, yes, it's unreported, my Lord, unfortunately. But it's also a very important case, and specifically because the judge actually deals with all of these concepts and also looked at the common law and customary law and all of that. That had to do with forced marriage case, of course, and sexual exploitation. But the principles are still the same. Now, in this specific case...
You're taking me to page 51. Is that the portion where he says now this section?
That's correct.
Because he quotes section 11 up ahead.
Yes. Indeed, my Lord.
So that's at line 10 of the judgment. I'm there. I've got it open in front of me.
Thank you, my Lord. So in that specific case, I argued this, specifically as I'm setting it out now, that section 11 actually says it's not necessary, and the court agreed with my submission in that matter. And this is what he then says on page 51 thereof, when he then finds that when we are dealing with a child victim, it is not necessary to prove the element of means. Although, my Lord, I at the same breath also would like to say that I would almost want to say 99% of the cases, we in any event prove means when we're dealing with a tip case. But as a requirement, it is not necessary. We only have the act and then the intended purpose.
Well, it's interesting that in the Ngasana case, the judge refers to an article.
Yes.
Not the one that you refer to,
no,
because your one came later.
Yes, my Lord.
But that's the one by Creston.
Yes.
In the journal, and weaves into that argument the UN protocol.
Yes.
As well as reference to the Children's Act.
Yes, indeed, my Lord.
In coming to that conclusion. That's how I understood it.
No, my Lord, indeed. I referred the court then to all of those articles, and all of them were submitted, and it's clear that the Honourable Judge applied his mind and properly dealt with all of those authorities.
Because what I have here was a transcript of what was read in court. So it's not the written judgment.
Yes.
So that portion of the discussion one would normally not find in the text of the judgment.
No.
There would have been a footnote.
Yes.
And he says, by way of a footnote.
Yes.
So the reference is that
in his written judgment, it would be in a footnote.
And more often than not, lawyers don't read the footnotes nor go and check what those sources say, and that's where you get these arguments by counsel in court referring you to issues that are irrelevant or not appropriate.
Indeed, my lord.
And then references are wrong.
Indeed, my lord.
Because people don't look at the cases.
We are all human, my lord.
No, you would have realized the other day, I didn't take Ms. Nkabai on about Botswana.
No.
But I mentioned it was a judgment of Himstra.
Yes.
Now we know Himstra never sat in Botswana.
No.
I did it on purpose because I knew it was a Botswana case.
Yes, my lord, indeed.
Hence my reference to Himstra. And my reference to Lubaka is because in the judgment, not in a footnote, in the judgment itself, Nugent, AJ as he then was, refers to the Judge Akwo and says, Erasmus N, acting judge as he then was, referring to the 1999 trial.
Yes. Indeed, my lord.
So, yeah, I mention it because this is a typical way of understanding where the judge clearly explains that context.
Indeed, my lord.
I don't have heads from the defense on the elements of the offences charged. I don't know whether they might take a different view.
Indeed, my lord. My lord, that is why I am referring, my lord, to this specific matter of Nasana. Similarly, my lord, it was also found by Regional Court Magistrate Montgomery in the matter of Martini and another. That was also a matter that I prosecuted. So I have the...
Yeah, but the Regional Court Magistrate had no choice because they were bound by the judgment of J as it then was.
No, my lord, no. Nasana came after Martini. Martini was first and then came Nasana. So that is... For that reason, I'm not suggesting...
But it's a very persuasive, even though I'm not bound,
yes,
it's a persuasive argument.
Thank you,
as made out. And coupled to that, it seems that we the outlier, if it's a requirement.
Yes.
Because in international law,
it's not
a requirement when it relates to a child.
Indeed, my lord, indeed. And our legislation, our Pakutip legislation, to a great extent corresponds with the definition as in Palermo Protocol, our Section 4.1. It's just a little bit wider than in Article 3 of the Palermo Protocol. But
even if the purpose would be a requirement, is that just not an infringement, Mr. Rowe? Do you have to prove it positively, or is it an inference the court can draw?
The means, my lord, or the purpose?
That the exploitative purpose.
Yeah, no, the exploitative purpose, my lord, I was just dealing first now, not just with the means. So my submission in this regard is, although we are dealing with a child and we do not need to prove the means in this instance, my submission is that we actually do have the means. And the means is in the form of the exploitation of the vulnerability of our victim. And as defined, my lord, one can actually see the abuse of vulnerability is any abuse that leads a person to believe that he or she has no reasonable alternative but to submit to the exploitation. And that includes, but is not limited, so it's not an exhaustive list, but it includes taking advantage of the vulnerabilities of a person. And that vulnerability may result from, and in this case, my submission is, what is relevant is that we are dealing with a child. One can also consider the social background or circumstances and the economic circumstances, as I set out in page 4 of my heads of argument.
Well, I don't know how far you've taken the timeline and the plan. I'm just opening it up because I haven't seen this before this morning.
My Lord, when we deal with that...
So it seems to me that is it Ms. Herman that drafted this?
My Lord, it was a team effort between Ms. Hiraman and Captain Lombard, and then an insight from my side.
So I'm interrupting you because we're dealing with the means, the purpose. You say to me, we have to look at the social background, you have to look at vulnerabilities, you have to look at the relationship between the alleged perpetrator and the victim, and so forth. So when I was looking at it last night, I was wondering and asking myself, where do you start? Where do you start with your timeline? Now, we're fortunate in this case that we've had the evidence of the social worker.
Yes, which dates back to 2016.
Now,
if I'm not mistaken.
Is he Mbambo or Mbombo?
Mbombo.
Right. So you've got to go back to 2016.
Yes.
Then you get to the relationship between the father and Miss Smith.
Yes.
All the ups and downs went along, takes you along this route of her own vulnerabilities,
Yes.
talking about Miss Smith's.
Yes.
Weave into that the evidence of Miss Daniels.
Yes.
We now know, as a matter of fact, might have been a fact that was overlooked in the hustle and bustle of the trial, that Miss Smith herself was adopted at an early age by a grandmother.
Oma kind, my Lord.
Right. And then the attempts to adopt Joshlin by Miss Andrews and her family, the objection to that by Miss Smith. Fast forward, which is a fact that we'll get back to, the discussion on the 18th of February and the words used on both scores of Miss Lombard as well as Mr. Apollos.
Yes.
Pause there. Have a look in the rearview mirror at what was said to Mr. Goodseer. My family set up, etc. And you follow that line on the timeline. You said, I must take all of those circumstances into account.
Yes.
Then we put ourselves in the shoes of the role players. We've been there.
Yes.
It wasn't my first time to see those type of conditions. Grown quite used to it when I grew up. But you think about the child, the need to be protected
Indeed.
under those circumstances,
Indeed.
and the trust a child would have in those that are supposed to care for the child.
Indeed, my Lord. Which brings me to the third element.
Okay.
Indeed.
Now, I also want to understand your argument. So that's on my own reading and my thinking through it last night, after I received your heads in the early, it was 10 o'clock or so in the morning, I think. That's what you want to tell me.
Yes, indeed, my Lord. Indeed.
Because jumping from where the facts lie and principles.
Now that's why I thought if I could set out the law and also what we are relying on in this instance, and then we get to the timeline. If we then take it back, and if you keep these thoughts in the back of your mind, then it all becomes very clear. So my submission is, although we don't need to prove means, we actually do have means in this instance. And it's because of the abuse of the position of vulnerability of our victim, Joshlin, as set out.
But that's why I told you the other day, don't give me a he said, she said. Tell me a story.
I'm getting there, my Lord.
And then you gave me a he said, she said in the hits, but that's fine.
My Lord, I hope that when we deal with the timeline, it all will fit in. I had to deal with the evidence, and therefore I'm not going to read the evidence as it was summarized. We will only refer to the timeline. So I don't intend to underestimate my Lord's intelligence at all.
No. I might not make a lot of notes because I want to listen to you. I want to hear argument.
Thank you,
but
my Lord.
In my court, it's not a one-way street.
Thank you, my Lord. Thank you.
I think Ms. Herman and Mr. Harms are the only ones that appeared before me. It's always a nice engagement.
Thank you, my
and
Lord.
it needs to be robust because we need to clarify things.
No, of course. Of course, my Lord. So that's why I am happy in my Lord's exposition as you now explained this, and going to the economic and social circumstances. As I said, this now brings me to the third element. And the third element is actually, and has always been, when it comes to the selling of a person, that is our difficult one to define. Because, and more specifically so in this instance, because we don't have a victim. And more so when you deal with a child victim. The reason being, they cannot tell you why this was done. They cannot tell you whether this was for sexual exploitation, whether it was for labor exploitation, whether it was for child labor, if you don't have the victim, as we do in this instance. So that is why, my Lord, our argument is that in this instance, the exploitation, which is defined in the section 1 of the Act, in this instance, we are relying on to say it is slavery or practices similar to slavery. And please allow me to explain why we get to that submission. If you look at the definition section of the Pakotip Act, section 1, slavery is defined therein. Slavery means reducing a person by any means to a state of submitting to the control of another person, as if that person were the owner of that person. In other words, being controlled by the other person. Now, if we consider, in this instance, we have a child. A child is solely reliant on their parents or caregivers for everything, for their basic needs, for their safety, for their security, for everything that they need in life. Now, if we commodify that child and we sell that child and take that child away from the parents and give the child to someone else, that person would now have the ultimate control over that victim. In this instance, more so because of the age of Joshlin. She was only but 6 years old. That is why we are submitting that means that Joshlin is placed in a position of slavery or practices similar to slavery. In other words, the commodity becomes the belonging of the other person, whoever that person is that Joshlin was sold to. So that is our argument, that in this instance, it is our intended exploitation, the purpose for exploitation. That is what it is. My Lord, there is the other also option. If we consider Renz's testimony, she says that on the 23rd of February, when she and Kelly had that discussion in the house, that is when Kelly told her that she knows what she had done. Joshlin has been sold. She is being paid to keep quiet, and the people wanted her for her eyes in her skin. So there is the possibility to say that the intended exploitation in this matter might also have been for body parts, as it is one of the different exploitations in the Act. I've gone through the practice. If you look at the National Health Act, then an eye is considered to be an organ and skin is considered to be tissue, as I referred to in page 5 of my heads. But my Lord, I accept that we don't have anything further than just that which Renz have said. So the safe and the, if I may say, more convincing argument in this matter, I would say that the intended exploitation is indeed for slavery or practices similar to slavery.
Well, the way you frame the indictment,
yes, is that way.
Is that way, and
yes.
It falls under J,
yes,
under sub J, read with the definition
yes.
Of slavery in the Act.
Indeed, my Lord. I'm only dealing with this as an alternative, that it is there, but yes, that is why the indictment was drafted that way, and that is indeed our case. That in this instance, the intended exploitation was for purposes of slavery or practices similar to slavery, as I set out, because of the age of Joshlin that we are dealing with. And then the abuse of her position of vulnerability as the means.
Yeah, so it would be C, H, I, and J.
Indeed, my Lord. Indeed, my Lord. And then the Act, I did not specifically refer to the Act, but indeed in this instance, our evidence is that Joshlin was sold. So selling, if one looks at the definition of section 4.1, it's a person selling, exchanging, leasing, transferring, all of those different options. So in this instance, it would be selling. It could also be delivering Joshlin. It could even be argued to be exchanging in exchange for money, which is indeed just selling. But my submission is, in this instance, our case is, Joshlin was sold. She was also delivered. You don't have to have all of those acts or that conduct. You only have to have one of them. Thank you, my Lord. So those are the elements, and I will rest by that. Then, if we look at the interpretation of certain expressions, and this is an interesting one, my Lord. If you look at section 2, it deals with the form of guilt, actually, that one requires in terms of this legislation. Because it's similar to what we have in the POCA legislation. We get reference to a person that knows or ought reasonably to have known. You will note that section 4.1 doesn't have the words intentional or unlawful. The indictment also does not, because the section doesn't mention it. Section 2 deals with the form of guilt. So what should be proved is that the accused knew or ought reasonably to have known. In this instance, we submit that if the court accepts the evidence as adduced, then they all knew that this is what they were doing. Joshlin was being sold for the purpose of exploitation. I neglected to say one thing, and it might be because I wasn't looking at my head, but when one deals with section 11, my lord, then this is usually, and that's on page 4. It was also in the indictment, my lord, but just on the purpose, this is generally referred to as the defences section, because it says when it is not an offence. In other words, if the victim consents to, or the parent or the caregiver, the guardian who has control over, consents to the intended act or the intended exploitation, that is no defence. That consent does not give or substantiate a defence thereto. A second leg of that also, my lord, is that it's not necessary for the intended exploitation to actually happen. We only need to prove the purpose of exploitation. And that is what section 11 in essence says.
Well, the indictment itself sets it out as well.
Yes, my lord.
And
indeed,
at the time when the charge was put on the 3rd of March,
yes,
I didn't look at the act before that, and I found it strange that the indictment was drafted in the way it was. Now I know.
Thank you, my lord.
Because I recall you reading it out, and I'm saying to myself,
what am I missing?
What am I missing here? Why is the indictment put the way it is?
Indeed, my lord.
Yeah.
But that has, because of through the years of cases and developing, and this piece of legislation was written a long time ago, and there were so many different insets and additions. There were even amendments to the legislation. So yes, it's been a while. It's come a long while, but yes. My lord, if I may then, I think I've dealt with everything on trafficking in persons.
Yeah, you've dealt with section 2 now,
yes,
which is the defences.
Yes.
Section, yes, I'm with
Thank you, my lord. So I've dealt with 2 and I've dealt with 11. Those are the important ones that I wanted to bring to the court's attention. I'm now on page 6 of my heads, dealing with section 204. Now, my lord, my apologies for not having referred the court to the Kumani matter. As you said, I will definitely look at it. I will study it.
Now, Kumani deals with the circumstantial evidence, going back to Rens, but coincidentally, in Kumani, all the other issues are dealt with that we encounter in this case.
Okay.
So
I'll definitely study it, my lord.
It's not a long judgment. It's a quick read. It's an easy read.
Thank you, my lord. But I did refer the court.
No, I was just told that some more stuff has been uploaded.
Thank you,
but I'm not going to look at it immediately. Once we get there, we'll open it up.
Thank you, my lord. Thank you. So, my lord, it is trite that when we deal with a section 204 witness, the court has to apply a certain measure of caution. And that is just because such an accomplice has intimate knowledge, usually, of the offence that has been committed. And for that reason, it's easy to apply the facts and falsely incriminate someone else, or substitute yourself by someone else. So that is why a court needs to apply caution before just accepting the evidence of a 204 witness or accomplice witness. My lord, I respectfully refer the court to the matter of Klape Zulu. and others, 1965. I know it's an old case, my Lord, but it does set out that when evaluating the evidence of an accomplice, that there has grown up a cautionary rule of practice requiring recognition by the trial court of the foregoing dangers, the safeguard of some factor reducing the risk of a wrong conviction, such as corroboration implicating the accused in the commission of the offence, or the absence of gainsaying evidence from him or his mendacity as a witness, or the implication by the accomplice of someone near and dear to him. Then the judgment refers to a number of other appellate division cases, and then satisfaction of the cautionary rule does not necessarily warrant a conviction, for the ultimate requirement is still proved beyond a reasonable doubt, and this depends upon the appraisal of all the evidence and the degree of safeguard that is necessary. Now, my Lord, it was argued in the unreported matter of Majola and two others, which I refer the court to. It was argued in that matter that it is then a rule of law and requirement that you need to prove, or that there should be corroboration implicating the accused before a conviction can be sustained on the evidence of a 204.
Can I interrupt you by saying the following? It's easy to put labels. Cautionary rules, yes, that's how it's been labeled.
Yes.
Then you're going to have
single witness.
We're going to get to, because that's going to be the argument. Why there was a need to include Section 208 in the Act, I don't know, but it's there. So all it says, you can convict on the evidence of a single witness. But over time, these practices that became known as cautionary rules have developed. But the starting point is, you don't evaluate the evidence in compartments.
No.
You look at it holistically.
Yes.
And is it but not a common sense approach to determine whether the evidence of a witness in some respects might not be trustworthy or credible, but it is reliable.
Yes.
And then you might have to look for forms of corroboration to ensure the reliability of that evidence. For example, we're going to deal in detail for the next day. I have my way only for this day, but it seems we might go over till tomorrow with Laurentia Lombard.
Yes.
You're going to look for corroboration on certain aspects from the state's perspective.
Yes.
I'm going to be told in argument by the defense most probably,
all the criticism.
Liar, liar, liar.
Yes.
I'm not going to add the other part to it. Therefore, don't even take the evidence into account.
Yes.
You're going to argue, as you told me the other day, there's a golden thread.
Yes.
So we're just going to see where the threads on your argument is going to be more wound and strengthened so that it becomes unbreakable for the test of reliability.
Indeed, my Lord. Indeed. Indeed. And that is what we tried also with the mind map, but we will get there.
So you don't have to refer me to those cases.
Thank you, my Lord.
Because it's trite.
Thank you.
And you've referred me to the textbook.
Yes.
Which is also just a summary of the jurisprudence in the leading book on evidence.
Yes.
It used to be called Hoffman and Zeffert. It's now called Zeffert and others.
Yeah.
Yeah.
Yeah. No, definitely, my lord. And I did refer the court to the very old case, and that is just for the principle thereof, that the mere fact that a person tells one lie does not mean that everything that that person has testified about is then a lie.
Well, it's the Gumeri decision,
Yes.
and that's the question I posed to counsel in the discharge application. It's the old
Yes.
Latin,
Yes.
falsum in uno, falsum in omnibus.
Yes, indeed, my lord. Indeed. Untruthful in one and truthful in others.
Yeah.
Oh, yeah. Indeed. So that's the reason why I've just referred the court to that. And then State versus Francis, of course, it's not necessarily expected of an accomplice, before his evidence can be accepted, that he should be wholly consistent and wholly reliable, or even wholly truthful in all that he says.
Now,
and I think that is what the court had just also said.
Now I'm going to fast forward you because
Yes.
we're going to deal with Lorenzo Lombard.
Yes.
When you apply the common sense approach,
Yes.
cautionary rules,
Yes.
in that as well, to a typical 204 witness,
Yes.
you will in most cases find a distancing him or herself from the offense initially,
Yes.
and then flipping. So you would invariably have two versions,
Yes.
or a watered down version and a full version.
Indeed.
So in the case of Miss Lombard, pre-13 to 15 March, and more particularly 20th of February, her version was different.
Yes.
The night of the 19th, with Kobese and Gongota getting there, it was one. The next day, it was slightly different to when she spoke to Sekhobe,
Yes.
Constable Sekhobe. Her evidence of the 19th, she says, I told Kelly, but you know what you did to the child. Right?
Tell the police.
Now we know the circumstances that night at their house because of Ayanda, and whilst I mentioned his name, there's no evidence about Ayanda in this case at all.
Yes.
Except for suggestions that were made.
Indeed, my lord.
But there's not a single piece of evidence that implicate Ayanda in anything.
No, my lord. In fact, Lombard's evidence was that it does not. It couldn't be.
So I don't know why so much mention was made of him in the case. Because if the accused wanted to implicate him, they could have come to the box.
Yes.
Just on a side note,
Yes.
because I've mentioned the name.
Footnote, my lord.
So then it was different. Right? She tells Constable Sekhobe about what happened on the 19th. That's the day thereafter.
Yes.
Doesn't come out with anything. Then we have arrested 13, go to Captain Salia 15. Now it's a half-truth.
Yes. Indeed.
It's a watered-down version. Right? Then, between the 10th of October and the 16th of October, consultations with Lombard, Van Tonder,
Yes.
lands up in the statement of the 16th.
Yes.
All right? Commissioned on the 24th of October.
21st.
21st. I'm speaking from memory. I'm trying to recall. But I know that the last consultation was on the 16th.
Yes.
But then it's reduced to writing sent between Lombardo and Van Tonder.
Indeed.
Now a witness comes and testifies, and you get confronted with your prior contradictory and or not a full disclosure statements.
Yes.
How much weight is to be attached to those differences?
Well, my lord, case law suggests that Breiners, as an example of a case, there shouldn't be too much value attached to that. Definitely when one considers the affidavit of a witness in contrast to the eventual testimony in court. There are bound to be differences.
No, I'm just talking about the different statements made, whether they were in affidavits or not, between a witness coming clean,
yes,
or to use the words of Mr. Apollos, hartskoonmaak,
yeah,
or the words of Mr. Van Ryn in his statement, die waarheid te praat.
yes.
How much weight do you attach to contradictions that then come about
Yes.
between the two different stages, or sometimes it's a run-up?
Yes.
Remember, I started on the 19th,
Yes.
and then it grew, and then 13, 15 March, and then it grew. So it was a progression.
My lord, and
How much weight do I attach to that?
my lord, I submit with respect, you cannot attach much weight to it at all. In this instance, which actually is more so, is we have a testimony that this was an agreement. That's why I was going to be paid. I was going to get payment for my silence. So therefore, I did not tell the truth initially. I did tell a lie. And when I realized now I'm in trouble, I'm being arrested, I need to tell something. Okay, so I'll give you something, but I'm not going to give you everything. Then I spent time in custody. And then I realized, and this was her own testimony, I decided now I need to tell the truth, the whole truth, everything. I need to lay it bare. And that was the affidavit in terms of Section 204.
And then you're going to argue the differences then between coming clean or flipping fully.
Yes.
And it's not spun around.
No.
Which also changed.
Yes.
It became swinging.
Swinging.
But we won't go there now. That's going to be fun later or tomorrow. The issue is on the then eventual statement, that statement between 10, 16, 21 October, that period. Is there so much difference between that and the evidence in court?
No, my lord. I respectfully submit, no, definitely. There are differences. I highlighted them, and I highlighted two, which I think were the most important differences between, and this is her confession to Captain Sillier and her testimony, or then the 204 and testimony. To my mind, and I submit that her 204 and her testimony is similar. When there are contradictions, they are not material, they are not of importance.
But we're going to come to a reliability later. I just thought,
Yes.
as a matter of principle,
Yes.
is there something to be said that you have to nitpick at this stage in order to find
Yeah.
compliance with or satisfaction of the cautionary rule?
No, indeed, my lord. And one would actually expect there to be those contradictions between the initial version and the ultimate version. But my submission is the 204 and her testimony is very similar. Contradictions or differences are minimal and not material in nature. There were two important contradictions between her testimony and 204 in contrast to the confession. And that is whether it was one trip on the Sunday to the polo or 2 trips, whether Buddha was included, and then the other one, I take that as one, and then the other one, whether the discussion about the money was only on the Monday or whether it was on the Sunday and the Monday. Testimony, and she explained the reasons for, and I know that the defense is going to nitpick and show all those differences. To my mind, those are the 2 biggest contradictions between her initial confession and her 204 and testimony. But my submission is, my Lord, one would expect those differences precisely for that reason. She has now had the opportunity of almost from March to October, 7 months in custody before, and time to reflect, and that was her testimony. I had lots of time to think about this. I realized I need to tell the truth, and that's why she then told the truth. So, my Lord, those are my submissions, and as set out, my Lord, we will definitely argue that there is, although there's criticism, yes, there is. One needs to take into account the person, Laurentia Rombon, and yes, she's the most important witness to our case. But one needs to take into account her background, who she is, prolonged drug use. All of those factors do weigh down and affect her. But, my Lord, my argument is, when one considers everything that she said, then there is that golden line of truth.
Well, we saw the transformation.
Yes.
With our own eyes.
Yes.
We saw her on Exhibit 1 with Captain Celia. I made comments when she testified. She told us that prior to her arrest, how often she was using the drugs. And by then it was 16 years of prolonged use.
Yes.
2 to 3 times a day.
Yes.
And then you saw the video.
Yes.
Of course, there wasn't an allegation that she was sleeping whilst giving the statement, because her eyes were always almost closed. But, and that might be a factor to be taken into account in evaluating the later version that she gives. It might be.
Indeed. Well, look, so when we get to the evidence, that's exactly what I did and tried to highlight. I know my Lordship said, don't do he said, she said, but just an explanation. I started, contrary to how we led the testimony in this matter, to set the scene first and get to it. When I'm dealing with my heads in argument, we focused on our most important witness, who was Laurentia Lombard. So I then start off with her testimony. I do deal with what I regard as contradictions or criticism, but my Lord, I do respectfully and we submit that her testimony in essence, despite the criticism, despite the little inconsistencies, is still reliable, trustworthy, and can be relied on as credible witness and credible evidence. My Lord, from Renz's, and I really do not intend to go through.
No, we're going to get to her in a moment, because that's your, from paragraph, from page 8 onwards.
Yes, my Lord.
But maybe you can just deal with 2.3 of your heads and let's get it over and done.
Okay. All right. Thank
because
you,
then we're going to go to the evidence.
Thank you, my Lord.
And when we're going to go to the evidence, maybe when we deal with her evidence, you can reference the ones where you find the corroboration, so that we don't do a he said, she said in that regard. So we're going to go through her evidence and then try and find the touch points, which will also come onto your mind map later when you get there. But just so that we understand that, I just want to dispose of this question of the failure
to testify, my Lord.
Testify now.
So, my Lord, I referred the court here to the Constitutional Court matter of Bosak, and more specifically, paragraph 24 thereof, where it says, the right to remain silent has application at different stages of a criminal prosecution. An arrested person is entitled to remain silent and may not be compelled to make any confessions or admissions that could be used.
Can we pause there? When I indicated to you earlier that I went to paragraph 23, right? Because of the context. Now, you don't have to read that, but I want you to read because the public has an interest.
Thank you.
That they hear what the Constitutional Court said.
Thank you.
But context is everything.
Yes.
So, in the Bosak matter, the type of charge that he was facing on the ones where this were applicable,
yes,
related to funds being paid into trust. So you were looking at two things. You were looking at the general deficiency,
yes,
but it was also the forgery,
yes,
issue. And then the decision was made he was not going to testify.
yes.
So the evidence was not as clear and crisp on those issues.
Yes.
And the Constitutional Court then had to deal with the right to remain silent, but it also relates to the right not to incriminate yourself.
Yes.
And then Langa, DP as he then was,
Yes.
later on became the Chief Justice, for people that don't know. Then said in the judgment.
Yes.
And have you looked at the footnotes?
I did, my Lord. I will not say that I looked at each and every one. I'm not going to lie, definitely, and that's not on record either. But I did read the whole judgment comprehensively, my Lord, if that suffices.
Yeah. So you're going to go right down to the end of paragraph 24 of the judgment.
My Lord, actually, if the court will allow me, from paragraph 24, I think that whole paragraph in itself.
That whole paragraph is important.
Yes, my Lord, that's my submission. That whole paragraph.
So I'm going to allow you to quote it.
Thank you, my Lord. So in paragraph 24 it says, the right to remain silent has application at different stages of a criminal prosecution. An arrested person is entitled to remain silent and may not be compelled to make any confession or admission that could be used as evidence against that person. It arises again at the trial stage when an accused has the right to be presumed innocent, to remain silent, and not to testify during the proceedings. The fact that an accused person is under no obligation to testify does not mean that there are no consequences attaching to a decision to remain silent during the trial. If there is evidence calling for an answer and an accused person chooses to remain silent in the face of such evidence, a court may well be entitled to conclude that the evidence is sufficient in the absence of an explanation to prove the guilt of the accused. Whether such a conclusion is justified will of course depend on the weight of the evidence.
Is there an of course?
Sorry, it's not. It's
Yeah.
My apologies. Well,
no.
It will depend on the weight of the evidence.
Don't be flustered, right? You want it to read, of course. So all I'm saying is when, if it's transcribed, that the of course must just be put in brackets, because that's not part of the quote.
My apologies.
Yeah, good. But you may continue.
Thank you, my lord.
I'm following the judgment from the text as you're reading. That's why I knew the words of course weren't there.
As the court pleases, my lord. What is stated above is consistent with the remarks of Madala J, writing for the court in the Osman and another versus Attorney General Transvaal, when he said the following: "Our legal system is an adversarial one. Once the prosecution has produced evidence sufficient to establish a prima facie case, an accused who fails to produce evidence to rebut that case is at risk. The failure to testify does not relieve the prosecution of its duty to prove guilt beyond a reasonable doubt. An accused, however, always runs the risk that, absent any rebuttal, the prosecution's case may be sufficient to prove the elements of the offence. The fact that an accused has to make such an election is not a breach of the right to silence. If the right to silence were to be so interpreted, it would destroy the fundamental nature of our adversarial system of criminal justice." My lord, and that is what our constitutional court, the highest court, says in this matter. If the prosecution makes out a case that the accused needs to answer to, it's then a choice they make when they don't answer to it. And the court may then accept the evidence that was produced as conclusive and convict. And then they can't cry afterwards, "I should have," because it's an informed decision, as it was informed and confirmed by this honourable court when that specific election was made, not to testify. So, my lord, to sum it up, the state submits that the accused, in fact, had a case to answer to. That is our submission. They decided not to take up that opportunity. It was an informed decision. It might have been the wrong decision to make under the circumstances, and the state submits that it was indeed the wrong decision to make, and that the court may then accept the only evidence which it has, which is the state's case, the state's evidence. In the absence of anything rebutting it, that is the evidence that we have to deal with. My lord, so my intention is that when I'm looking at the time...
I'm looking at the time not to limit you. I'm not going to limit you. As long as we finish argument by tomorrow afternoon.
No, my lord.
But argument is intense. Not only for counsel, but also for myself.
Yes.
Because one needs to concentrate all the time. So I'm going to allow counsel on both sides. When you think you're at a comfortable place to take a break and you want to take a 5-minute breather or a 10-minute breather, you can request and I will consider it. So I saw now that we've been busy for an hour and a quarter, and I know we're going to move to a new and intense section.
Yes.
So if you want to take a break now for 10 minutes, we can do that.
My lord, I please request that we do that. We are going to, from now on, my lord, as I set out, although the evidence is summarized,
you're going to put it...
We're going to look at it there and in a timeline.
And we're going to have a discussion about it. Good.
Yes.
Let's suit the defense. A 10-minute break. Let's take a quarter of an hour. Let's take it till 10 o'clock.
Thank you, my lord.
It will give you time to test your systems so that we don't get frustrated with that. Ms. Naidu-Chetty, can you just... I think we need to refresh here. And then you can just open it here for me as well. Are you going to the mind map or are you going to the timeline?
No, my lord, we're going to the timeline.
Let's just see during the break that I have it open here. So if I can't see on the screen.
We did try to make it big enough, my lord. I hope that it will be visible.
I came well prepared this morning, except that some journalists thought it's appropriate to do their live recording with the camera facing this way whilst I'm setting up. But maybe they didn't see me. Till 10 o'clock. Court adjourned. Yes, thank you. Thank you, Ms. Sonnepoel.
Thank you, my Lord. My Lord, as indicated, the summary of the evidence, all of the evidence, was divided into the main trial and then the trial within a trial I did separately, although it has been incorporated into the evidence as a whole. But in my head, it deals with the evidence from page 8 to page 45. So what we have done is to put it in by way of a timeline, include all of the evidence as it is. So if the court will allow me,
certainly,
wish to then deal with that.
Yes, again, if I don't look at you, because I've got a better view on my screen here, and it's in a fairly good resolution as well, so much easier read.
Thank you, my Lord.
Thank you.
Thank you, my Lord. My Lord, may I just pause for a minute? We are not trying to say lecture. This is new to all of us to adduce in an address, electronic format. My Lordship asked for a mind map. This is what we call a mind map.
No, that's fine.
So it's just meant as supplementary to the heads. And that is the corroboration mind map, yes.
Yeah,
model,
this,
which we will deal with later.
This is how I know it to look like, but not everybody's used to working that way, because you need to think laterally.
No, indeed.
And focus on 10 items. But I will, thank you for this. I'm definitely going to use it.
Thank you, my Lord.
In my preparation of the
it's
judgment.
My team.
Thank you.
Thank you, my Lord. All right. My Lord, so in essence, this matter relates to Joshlin Smith, who was 6 years old, born on the 23rd of October 2017. And may I pause here for a second? When I was going through all of the evidence again, I realized one thing. Both accused number 1 and 2, when they testified in the trial within a trial, referred all the time to the child, never referring to her on her name. My Lord, to me, that is a way of making it impersonal, taking that person out of it. And that is why it's so apt that
the name was only referenced on questions.
Yes, when the police would have asked, where's Joshlin and what have you done to Joshlin?
I've also picked it up, it was always referring to the kind.
Yes, my Lord, definitely. And she's a beautiful little girl. My Lord, this is where Joshlin stayed and grew up, and we saw that house when we went on our inspection in Loka. She was last seen on the 19th of February 2024 in Tsitsiratsitsi, Middelbos. Joshlin's home, where she resided with her mother, Kelly, her mother's boyfriend, Buddha, and her 2 siblings. My Lord, and this is our case, that there was a plan. The plan was pre-planned already by Kelly the previous year, but the actual plan, came into being between these 4 role players. Jack Quinnapolis, Stefano van Rijn, Raquel Smith, and Laurentia Lombard, aka Rens.
Is there a reason why you chose the pictures that you chose?
My Lord, I will not take responsibility.
No.
No, I meant that as a joke, my Lord. I absolutely meant that as a joke. No, it's...
No, I see the happy
faces.
The happy faces.
Yes, my Lord. Happy faces. All of them except Rens. Rens is not very happy in the picture. Thank you, my Lord. Then, if we condense what we are going to deal with in the timeline onto 1 page, then this could be seen as a mind map of the evolution of the timeline. So if one starts there, then initially the plan was revealed to Stephen Coetzee, the most important corroboration evidence for Renz's testimony, which was in August of 2023 already, when the plan was already at that stage indicated to Mr. Coetzee. Then
are you going to zone in on that?
Yes, I will.
At a later stage?
Yes, madam, I am definitely going to.
Because immediately when you say that time and place on Stephen Coetzee, who's also a single witness,
yes,
may be relevant. You will recall and other witnesses, the route taken by Ms. Smith to work in the morning,
yes,
coincides with the place where and the approximate time that Mr. Coetzee encountered her, as he testified in August of 2023.
Indeed, my lord, with the added that she then pointed towards the direction of her house to him. Yes.
And the existence of a blue-colored house that we saw when we were there. In fact, we parked on or about that spot that he was describing.
Indeed, my lord. Indeed. So from August 2023, we then go to the school holiday where Joshlin was staying with Natasha Andrews and her family. That was the school holiday before the school year started then. And then from then on to the 18th of February, where the police officer comes with the inquiry into the chicken theft investigation, and Renz witnesses the argument between them. That develops to Renz overhearing accused number 1 and 3 speaking, Joshlin being taken to a white polo by accused number 3, accused number 3 informing Renz of the plan, accused 1 and 2 being present at the residence at the time, and then the Sunday evening argument that Paulina Chosa is a witness to.
And she places Renz
on the scene.
On the scene by saying she initially thought it was a male person until she saw the bust.
Indeed, my lord. And she also referred to her as the one with the short hair. And then that then comes to the execution of the plan, which happened on the 19th of February, where accused number 3 gives delivery instructions. All the accused were present at the time and confirmed the division of money. Then the handing over to the occupants of the polo, and then the late night reporting to the police. That all happened on the 19th of February. After that, my lord, we then go with the missing persons inquiry that was opened, FCS starting the investigation on the 20th of February, the commencement of the search operations. It develops up to the 29th of February, where the provincial organised crime team then takes over this investigation, and that investigation progresses to the 4th and the 5th of March, where there was the interviews of all the people, the arrests, the statements that are taken, leads to the first appearance in court, and then the arrest of Renz thereafter. My lord, this court has heard the evidence of all of the police officers who testified here about the extensive search that we had in this matter, with the community's involvement, all of the resources spent, nothing being saved, my lord, in order to follow up each and every single lead, tried to find little Joshlin, which up to this point, unfortunately, has not yielded any positive results. So if I may then deal with the timeline, my lord, which then starts on the August of 2023, early morning hour, very cold winter's morning, when Stephen Coetzee meets with Kelly close to her house, and the conversation that they then have at that stage. The next time that Stephen, that's an important occurrence when Mr. Coetzee meets or sees Kelly, is in the school holiday of September, October, when on a Saturday morning, he also, I think it was Orion Street, if I'm not mistaken, he sees her walking, pushing the pram, seeing the 3 little girls in between them, calling of Joshlin. He calls Joshlin and he sees her, and he describes her as having the most beautiful pair of eyes. That was his precise words under those circumstances. Then Sunday, the 18th of February, is the next important date. Here the police visits Buta regarding the theft of chickens, which is not in dispute, except for the day. Then the reason for the visit is also not in dispute.
Can we just pause on the day?
Yes.
Of course, there's the statement handed in that places on the 17th, but that witness was never called.
Yes. Indeed, my lord. So there is no evidence to gainsay what Miss Rensha Lombard then actually testified about, that it was on the Sunday and not the Saturday. What can be accepted in any event is that the detective was there and it was for this purpose. Definitely.
Well, it's common cause. It was never disputed.
Yes.
With her.
Yes. It was only the day,
that
Saturday.
There was the chicken issue.
Yes.
But Ms. Lombard places the chicken issue, that argument that ensued, and the breaking of the window and so forth. That was on the day that the detective was there.
Yes.
She's corroborated as to where the vehicle stood,
Yes.
the buggy. Corroborated about Mr. Apollos going to the buggy. Then, because that was never disputed, in fact, it was put to her that was the situation, for what it's worth, because it's not evidence.
No.
But then the important, is it Miss Tsosa?
Probably now.
Miss Tsosa places it on a Sunday.
Yes.
And she gives her reasons why she placed it on a Sunday. And then admitted evidence, to the date of a discussion that took place in the house of Mr. Apollos and Miss Smith, comes from Mr. Apollos.
Yes.
And he placed it on the Sunday.
Yes. It does. Indeed.
I'm fast forwarding now, but
Yes.
I told you we're going to plug in as you go along the timeline.
Oh, indeed, my lord. Indeed.
Remember what we discussed earlier in satisfaction of the cautionary rules.
Yes.
So you look for
Indeed.
corroboration, if any, to determine reliability at the end of the day.
Yes. Indeed, my lord.
Now I'm still with you. I
Thank
hope
you.
I'm following.
Thank
Because
you.
I'm concentrating on your written words here, that's in telegram style, and
Yes.
trying to think
Indeed, my lord.
about the evidence. Yes,
Indeed,
thank you.
my lord.
We
So,
are now on here.
Rens, in the third bullet, my lord, under Sunday the 18th of February, Rens was present at Buta's residence, and she then witnesses an argument between Kelly and Buta, and that is where Kelly then breaks the window and also threatens to stab Buta. Rens then also overhears a conversation, although she places it a little bit later in the day. She says she first returned and then came back, but she overhears this conversation between Buta and Kelly about Joshlin. This is Kelly and Buta's conversation, and this was also confirmed by Boeta in his own evidence that there was this discussion about Joshlin, about the involvement of the family, and my lord, that forms part of the statement which he indicated was coming from himself. And then just to add on to that,
he recanted that after the weekend.
Yes, my lord, very
But that's in the
coincidentally.
inquiry, but the statement itself,
Yes.
that's the evidence.
Indeed, my lord. Indeed, my lord. But whilst we are dealing with this, may I please just one last aspect on that issue. Mr. Kutsia's evidence, he only refers to Kelly in his testimony. He says Kelly told him that she has a terrible family. And that is why she is arranged and the children will be taken away. If one, however, considers his affidavit, which was handed in by the defense in cross-examination, in that affidavit he actually refers to that she added on and said, then Boeta and I will be able to live in peace. So he didn't testify about that little bit, but it is part of his affidavit, was part of his affidavit that was adduced. My lord, I'm moving on to the next slide. Rens is now still overhearing this conversation. Then she hears the telephone ring and Kelly has a conversation with somebody in which she speaks in English.
Can you just pause there for a moment on that point? Just want to quickly have a look at now on the list of witnesses.
Yes.
Witnesses number 53 and 54 were from Vodacom.
Oh.
Now, I anticipated, and I just want to clarify because it might, because I don't know what statements were in the docket, so I'm anticipating possibly a Teixeira point being taken. When I heard that evidence from Rens, I was aware that I saw witnesses on the witness list from cell phone providers. Now, normally, if there's evidence to support the call and you have the device or you have the SIM card, one often finds that evidence.
Yes.
Does that relate to that call or not?
My lord.
These two witnesses that were not called by the state.
My lord, there were phone records obtained, different numbers. My lord will recall the evidence of Michaela Daniels, who said it was very hard to keep track and in contact with Ms. Smith because the phones changed all the time. My lord will also recall that as far as accused number 2 is concerned, in his statement he refers to my girlfriend's number, which was included in the cell phone. Accused number 3, there's no evidence whatsoever of any cell phone.
No.
So there's no cell phone for 2 and 3, and 1 changed in cell phone numbers the whole time.
Why I'm mentioning it to you now, because I suspect that when it comes to Pumza Sigaka, that the Teixeira argument might also be raised. Despite Sergeant Sangozi's evidence, we cut it short because witness was made available, and that might change the whole Teixeira argument, but it also opens up another possibility, and that's me exercising my discretion in terms of section 1862, I think it is. Yeah, it is. Yeah, it's not 1862, it's 186, where it says the court may call a witness or call witnesses, which is a discretion, and that discretion must be exercised judicially, and only where it is essential and it would lead to a just decision. But that's coupled also with other issues, factual issues.
Yes, indeed.
No, I'm just, whilst we're on that point, I just wanted to
No, my lord, so I can...
clarify that.
I can state that the phone records were requested. All of those phone records were filed. They are in the docket. They were disclosed. The state did not lead any of that evidence. The location of the towers in this small area is so close in any event to one another that one cannot make anything of it. So there was nothing that could take the case further this way or that way. And that's the reason why no evidence was adduced, but it was of course disclosed, and there was nothing in it, my lord. Even phone calls to Pumza, there was no phone contact even. My lord, so yes,
yeah. You were on bullet number 2. You were going to bullet number 2 on slide 8.
Thank you, my lord. So Kelly takes Joshlin to a white polo, and there she speaks to a woman. She describes her as a Sangoma because of her appearance. My lord, I know that defense is going to make a lot about that, but that was her inference that she drew, seeing her. She has seen a person before, and that is what she understands to be a Sangoma. That's how she described her. Rens sees Kelly receive something. At the time when she receives it, she looks around to make sure nobody sees and puts it into her pants, and she then returns with Joshlin. Rens overhears Kelly tell Buddha that she has received the money from the Sangoma and that it is 20,000 rand, because now Rens has moved back from where she was hiding behind the rocks to the house, again standing at the position of the broken window when she overhears Kelly saying this to Buddha. And that is when she then enters and also sees, when she comes around the corner, that Stefano, accused number 2, is also there. Kelly tells Rens that she has now done something bad. She has sold her child, Joshlin. Kelly informs Rens that she will receive 1,000 rand and Stefano will receive 1,200 rand. At that discussion, Stefano and Buddha were present during this conversation, and both of them, Rens and Stefano, accepted this and accepted the offer of that money. The evening, there's then an argument between Kelly and Buddha, and this is in relation to Paulina Chosa's testimony. Paulina watches as Kelly drags Joshlin into the residence and says, "Ek sal jou wys." Buddha then informed Captain Lombard about an argument, and this is during the interview of the 25th of February. He did, in fact, inform Captain Lombard that there was an argument, and he confirms that the children were present during that argument. I'm sorry, Ms. Naidu Chetty?
Yes, thank you.
Thank you, my lord. I'm on the next slide. Joshlin and Requin were not sent to school on the 19th of February. We have differing reasons for that, but that was a decision that was taken that they were not going to go to school. According to Rens, she arrived early morning, this is now on the 19th of February, at Kelly's house. At that time, Stefano and Buta and the children were all present. Kelly then gave instructions as to how the handing over of Joshlin will take place, and that Buta must ensure that Joshlin is ready around 2 o'clock for the handing over to the people to take place. Kelly leaves with Rochelle early morning, going to Carlin Zieger's house. She arrives at Carlin Zieger's. She receives the house keys of Kelly Zieger's house, and she then leaves Carlin Zieger's house. Later that morning, Rens and Buta smoked a quarter mandrax, and Stefano joined them. This is also confirmed by both Buta and Stefano in their initial affidavits. Just before 2 p.m., Kelly left Carlin Zieger's house, claiming to go to her home. And she, in fact, does go to the home, and she takes Joshlin to the same person in the white polo that she saw the previous day. She and Joshlin get into the car. The vehicle drives off with Joshlin and Kelly. And at that time, when this happened, Buta, Stefano, and Nilo were present at the house. Kelly then returns to Carlin Zieger's house approximately 30 to 45 minutes after she had left it, fitting into the timeline of this handing over to take place. Kelly returns home later that afternoon at approximately 5 o'clock. Kelly, Buta, and Stefano then went to go fill up the gas canister. They bought tick and they smoked it. And thereafter, Buta and Stefano, with other friends, spent the evening in Talmakis Street, where they were smoking drugs.
Before you go to the next slide, what do I make of the evidence of Kelly Zieger's insofar as it relates to the camera and the CCTV in her house?
Yes.
That, remember, she fetched the keys, Miss Smith fetched the keys from the mother, purporting to go to
Yes.
Kelly's house, the daughter. Of course, this name Kelly features quite a lot in this case because there was also a police officer with the surname of Kelly.
Yes.
But the footage doesn't show that she was in the house. What do I make of that?
My Lord, we do deal with it later when the police interviewed her and she realized that it wasn't there on the footage. It is in the timeline here, but our respectful submission is that the inference to be drawn from that is that she wasn't there. Kelly's testimony is, I see myself, I see the children. I went back to look the day before, that day and the day thereafter, and I can see us moving around in the house, but I never see Kelly. The only reasonable inference to be drawn, if that is viewed, is that that is a lie. Kelly purported to go to Kelly Zieger's house, but she never did. My Lord, you will recall that Kelly's testimony also was, Kelly Zieger's now, testimony was that the daughter doesn't like it to be dirty. So they had cleaned up. It would have only been the morning's dishes that was there, and she would have expected her to clean that in any event. So she couldn't, from her own, say that Kelly was in fact there or not. When she looked at the video footage, she wasn't there. So we submit, my Lord, that the inference to be drawn is that that was not the truth. She wasn't there.
Yes, thank you. We're going to slide number 10.
Thank you, my Lord. So, dealing with what happened later that night, Kelly now realizes that Joshlin isn't there, and Kelly and Namhla then search for Joshlin, and at approximately 9:30, she then reports Joshlin missing to the police. My Lord, you will also recall that it was Namhla's testimony that she said, after they had spent about 20 minutes waiting there in the street, Kelly comes out and says, she's just charging her phone, and it's at that stage that Namhla informs her, but you must alert the police, you must phone the police. Coupled with Renz's testimony that from the beginning it was the agreement that Kelly will report her missing. But at the time, Namhla tells her, report this to the police. Now the police is in fact contacted. Load shedding starts at 10 o'clock, it lasts up till 12.
Now, let's go back on the day.
Sorry.
Explaining the time between 5 and 9:30. Now remember, you also have the statement to the police that Ms. Smith wrote in her own hand.
Yes.
Which also gives us timelines.
Yes.
And Mr. Pollis tells, it's all now drawing inferences.
Yes.
And that's where Kumani will come in at a later stage and ready. And some people might still take me to Rex versus Blom. And the dual test in Rex versus Blom, I prefer to get closer in time. And there's a beautiful description of how to evaluate the circumstantial evidence in Reddy, referring to a mosaic. You would have heard me mention it as we were going along in the case. So Mr. Pollis tells the next day, he tells Mr. Milstein the reason why Joshlin did not go to school was because she was unwell. She had a cold. Now you have a mother that then leaves early the morning with the little one, goes to work, come back at lunchtime. No mention of Joshlin.
Yes. Yes.
My child's ill, she didn't go to school, because that's what Mr. Pollis said almost immediately the next day. Do you read anything into it? Does it form part of those vague tiles that when the sun shines on it, it gives a better picture?
Indeed, my lord.
Then, thank you. You come home at 5 o'clock. Where's my sick child?
Yes.
Nothing.
Nothing, my lord.
Then you decide, yes, you might need the gas because you need to cook food, that I understand. So not much is made of that.
Which you never cook.
Then you go and buy drugs. Then you come home.
Yes.
Zero concern.
Yes.
Then you go smoke the drugs. Zero concern. Then more hours pass. Where's my sick child? Zero. Because we know that Requin only came home after 6.
Yes.
As a matter of fact, that comes out in the evidence.
Yes.
And Requin is sent to go and see where the little one is. And Joshlin says, no, he found her, but Joshlin's not there. No alarm yet. I'm mentioning it now because you gave me the timeline.
Yes.
In your timeline, it's not highlighted. Are those not important occurrences?
Indeed.
Or omissions of concern
Yes.
to be taken into account? I'm just asking the question. Remember, we're in an argument. This is not a finding.
No.
Because that's going to fast forward to the evidence of Colonel Sibola, Ms. Hanif, Captain Lombard. One of the videos that Ms. Hanif uploaded that was shown, that one couldn't see it clearly when it was on that screen. With the jiving with the temple boys.
Yes.
So out of the conduct of a mother that on the face of it does not show the concern that one would have expected, that's one thing, but can it be corroboration for the fact that, and I'm quoting Laurentia on her own evidence, on the night of the 19th. Maar Kelly, jy weet mos wat jy gedoen.
Yes, vertel vir die polisie. Indeed, my lord. May I just add one little extra bit to that? The question remains, and this is Butta's testimony, or in his statement, when he refers to Joshlin not going to school because she was not well. Why would, if the one is not well, both stay at home? Because Riquan also stays at home. My lord, but then we see that changes. That version changes to the reason why the children were not sent to school was because of the school clothes, school uniform being dirty and not having money. That's also what she tells Michaela Daniels on the 26th of February. That is the explanation offered why the child did not go to school, why Joshlin did not go to school. When Mrs. Mart asks the same question, she stops crying immediately. The question is repeated but never answered. My submission is we see this progression because one realizes that being sick and now both children are kept at home, that one is not going to fly. Now it changes to the school clothes were dirty. All of that, I submit with respect, that the court should draw inferences from that. One, that this was the plan. The plan was from the start that they shouldn't go to school so that she could be delivered. And there was no care at all at any stage during that day. It was only much later that then a search was done, but stopped that night.
But turning back to the point, your bullet point now. We'll recall the evidence of the reason why they went to this particular house was because they were told that Joshlin might be there because she had walked with this person.
To Peter Makabastraat.
So now you get there, and it's now late. It's dark. My 6-year-old daughter is not where we thought that, because that was the information we get. Load shedding is going to start in half an hour's time.
Now you charge your phone.
20 minutes hang around in this house of a suspected person where you don't find your child. And you use the opportunity to rather charge your phone,
Yes.
then go and search further,
Yes.
or contact the authorities.
Indeed, my lord.
Is that also another feather?
Definitely, my lord. My lord referred to a mosaic I like to refer to it as a puzzle, maybe old-fashioned. But if all of those pieces are not there, even if just one is missing, it's not a complete picture. But all of those little pieces, and some might look very little and not have any color, but when all of them are in place, then only the complete picture is seen, similar to a mosaic. Indeed, my Lord.
There are some old authorities that refer to circumstantial evidence as feathers.
Yes, very light.
The Afrikaans expression was used, die vere in die smeltkroes
Yes,
raak later soos 'n meelsteen om die nek.
indeed, my Lord, when it becomes wet. Yes.
That's one of the old authorities, where it's described that way.
Yes.
Yes, thank you.
Indeed, my Lord. Thank you. So, Sergeant Kobese and Constable Gongota attend to this missing persons report that was made at about 9:30 that evening. Then Kelly goes to Garland and Kelly Ziegers' house. She also goes to Natasha Andrews' house because she's looking for a photo for Joshlin, which she doesn't have, in order to give that to the police for the missing persons file. Natasha Andrews and her family have always been in the position of looking after and assisting in the care for Joshlin Smith. That's where she finds the photo. Boeta is found in Talmaki Street in Diasville because he wasn't at home. They actually looked for him until they found him. Sergeant
And of course we heard the instructions being put to the witnesses.
Yes.
And then in his statement he confirms
Yes,
that he wasn't home.
indeed.
But when the state witnesses testified,
Something
it was
else
a
was
different version was put.
Indeed, my Lord. Indeed.
Maybe that's the reason he didn't come and testify.
My Lord, I can only speculate.
That box would have been hot.
I think so.
Yeah.
Sergeant Kobese and Constable Gongota go to Rens. Ayanda is upset by the police's presence at his residence, especially at night. An argument then ensues between Rens and Kelly. We've dealt with that. And then Rens tells Kelly to inform the police what she did with Joshlin. The police leave and go back to Kelly's residence. That's where the SABC 55 is completed. The statement is obtained from Kelly. And in that statement, she actually says that Boeta was not home on her arrival that afternoon. And she also does not mention Stefano. So it's not only Boeta that doesn't mention Stefano. She also does not mention Stefano. It's only Rens the next day that mentions Stefano. One definitely sees a close knit between the accused persons. That evening then, despite the fact that Joshlin is not home, Boeta and Kelly go to sleep. That brings me to the next day, my Lord, when Sergeant Milstein and Constable Sekobe are called in, and Kelly is now re-interviewed. Boeta makes a statement, but he does not mention Stefano's presence. Rens make a statement, but she mentions Stefano's presence. Then different reasons emerge for the children not attending school. I've referred to that. Missing persons inquiry is registered. It was registered just after midnight, the previous night. The teacher, Edna Mart, that contacts Kelly Smith, she doesn't give any answer about the absence. She's actually asked twice. She stops crying, and the call is then ended. Kelly, Boeta, Stefano, and Rens do not participate in this search. My Lord, and that, to me, is a very important piece of this puzzle. This is the parent, and it's also the guardian, if I may refer to him in that way, living with and looking after. My Lord, they don't participate. Kelly only, and I almost want to say, for the show that night, but never again thereafter. Buta never participates. Stefano never participates. Renz never participates. Why? The only reasonable inference to be drawn from that is because they knew that this would be a futile exercise.
Well, it was put to the witnesses again, only put, that the reason was because they were cautioned that the community was upset with them.
My Lord, but the community was specifically upset by the fact that they did not participate in the search. That fueled this whole uproar in the community. This is your child. Why are you not looking for your own child?
Now, can we pause there?
Yes.
It's conduct that's unexpected, that leads to, on the state's version, the animosity towards them. Let's take a deep breath. Let's listen to Langa DP in State versus Busak. Does that call for an answer?
For sure, without a doubt.
Absent which an inference can be drawn.
Definitely, without a doubt, my Lord.
Yes, thank you. You may proceed.
Thank you, my Lord. Lieutenant Colonel Sebola overhears that Kelly say, Joshlin has made me famous. This has been said on a number of occasions, but Colonel Sebola also hears this and testifies about it. SAPS and the community members are involved in the search. Kelly gives an interview when she stays at Kelly Ziegers' house that night, the 20th, where it's necessary for Kelly Ziegers to tell her that she must stort 'n traan darm, show a little emotion. Kelly Ziegers is concerned that Kelly Smith does not appear concerned about Joshlin's disappearance. Kelly Smith is eating and sleeping while Kelly Ziegers cannot do any of those things. Kelly Smith is interviewed by Shakira Khanif on the same evening, and the minute that she mentions Buta or the possibility that Buta could be involved, Kelly becomes aggressive and defensive, trying to protect and shield Buta.
So again, pause on that bullet point, and you might come to it later.
Yes.
Now, in this instance, Kelly Ziegers tells her to stort the traan. But there are also other evidence where she tells Mr. Apollos
Yes.
to show some emotion.
Yes, because the people will be watching them. This is at the prayer on the Sunday.
I thought I was doing well. Okay, continue.
Thank you, my Lord. But I will refer to that again, definitely. Kelly Ziegers notes, as we have dealt with, that Kelly Smith cannot be seen on the CCTV footage at our house on the 19th of February. I've already dealt with the inference we seek the court to draw from that Kelly was not at Kelly Ziegers' house on that day. The police launched a comprehensive search involving K9 unit, LCRC, uniformed officers, everybody to participate in the search of the area for Joshlin.
Yeah.
May
okay.
I proceed? Thank you, my Lord. We're going to the 23rd of February, And this is where Edna Mart and her colleagues are now also going to participate in the search. And there at the petrol filling station, Kelly appears out of nowhere, gets into Mrs. Mart's car. And she, Kelly, then tells Miss Mart that a Nigerian male told her that Joshlin is in a container on a ship en route to West Africa. Why Kelly decided to specifically mention this to Miss Mart is a mystery. But that is what she tells her. But more importantly, she then in a very softer voice whispers, "Onthou net, Boeta is nie skuldig nie. Just remember that Boeta is not guilty." Then Kelly alights from the vehicle and vanishes, just as quickly as she appeared. Once again, a little piece in that bigger puzzle or mosaic, my lord. The search goes on and intensifies. On the 25th of February, that is when Captain Lombard, and this was a Sunday, Captain Lombard then arrives in Saldhana and interviews both Kelly and Boeta. He notes discrepancies and red flags in their versions and in their demeanor and conduct in general. Boeta confirms the visit of a stock theft detective at his residence and further confirms the argument between him and Kelly on the Sunday evening and that the children were present during that argument. According to Boeta, Requin and Joshlin did not attend school because they both were sick. Boeta is evasive when he is questioned about Joshlin and when he is questioned about his relationship with Joshlin. He refused to answer.
Before you go to that, now remember this is 25-2.
Yes.
Boeta still says both of the children didn't go to school because they were sick.
Yes.
They were sick on the 19th.
Yes.
The day thereafter,
The 26th.
was when, because this was now to Milstein, it was to Lombard.
Yes.
Next day is the telephone call between
Her
Michaela
and
Daniels and Miss Smith.
Indeed, my lord. And then the explanation is offered about the dirty school clothes.
So that's most probably on the next slide, or not?
It is coming,
Okay.
yes, indeed, my lord. So Boeta is evasive when he is asked about the relationship between him and Joshlin and refers Captain Lombard to Kelly. He must ask Kelly about this relationship between the two of them, which of course must be puzzling and was indeed puzzling to Captain Lombard at the time. Boeta confirms Kelly came home later the morning. They smoked tik. She then returned to work. She did not stay long. My lord, the importance hereof is that this was not contained in Boeta's initial affidavit, this other visit in between for the smoking of the tik. This is something that also, as the time progressed, evolved, and then this is entered in, that she actually came and they smoked tik, and then she returned again to work.
On the evening of the 19th to Kobesi and Gongota, was there any talk about her returning home during the day?
No, my lord, not at all. It was only at a later stage that said that she had actually returned home for lunch. The initial was she had just come home after work and then found that Joshlin and Boeta were not there. But later on, that changes to say that she's actually also gone home during lunchtime. That was also Captain Lombard's testimony in this interview, that she then said, "Ek het verkeerd gepraat" in that statement. She actually did come home during lunchtime.
So on the early hours of the morning of the 20th, at 1:10.
Yes. She does not mention it.
Remember, that's when I queried the time.
Yes.
Because the cell register shows that they had visited the cells. So she says she came home at 10 to 2 on the 19th. But then it can't be the same as the going home to smoke.
Yes, that's an
Because what was told to Kobesi and Gongota on that night was that he wasn't home.
Yes. Yes, indeed, my lord. So that's why this is an extra add-on, this in-between visit to go and smoke, tik, going back, coming back for lunchtime, going back again, and then returning after work. So and that's why, and this is my submission, as the time evolved, so also did the story and the storyline and the add-ons that we get all the time. And it is precisely that, and the specificity or the lack thereof of the time when Joshlin would have gone missing that caused the red flags in the mind of the investigating officer. That's why he had unanswered questions and needed to re-interview all of these people. It's specifically because of all these inconsistencies, changes, add-ons, changing in details of that day.
Well, I took you to that statement for another reason. Because you mentioned this going home for tik on the 19th. Now, it's inconsistent with the version given by Mr. Apollos.
Yes.
So it's one of the red flags.
Yes.
Now, at the time when Captain Lombard interviewed them on the 25th, he had that statement
Yes.
of Miss Smith. Now, if you then fast forward to almost the end of the trial, and you then find the handwritten statement in a red pen by Miss Smith, according to that statement, when did she realize Joshlin was missing? This is a so-called warning statement.
Yes. I know that she places that much later, after 5:30, if I'm not mistaken. I don't have the document.
The statement,
in front of me.
the affidavit, the statement is marked QQ, exhibit.
Indeed, my lord. So it's, I think that is 15:45. My copy here, it's unfortunately cut off. I can't see the time. But on the original, my lord, the times are clear. Unfortunately, I wrote mine in mine.
Well, according to this statement that she wrote in her own hand,
Yes.
after her arrest, she said 11:30 het ek by aan Karl R50 geleen en 'n sakkie tik gaan koop by Gams. Ons, ek en Boeta, het alleen gaan tik. Voor ons na Gams toe was, het ek eers huis toe gegaan.
Yes.
And then she went back to work.
Yes, my lord. So,
Yeah. First inquiry she made about Joshlin, according to this statement, was at 16:45. But in the statement of the night of the 19th to the 20th, she realized Joshlin was missing at 10 to 2 when she came home.
yes, indeed, my lord. She, in all fairness, according to Captain Lombard's testimony, it's at that when he confronted her with that, she said, "Meneer, ek het verkeerd gepraat." So she tried to correct that. That it was later, but yes, my lord, indeed.
Now,
this is what she
now,
herself wrote.
There's no evidence from the defense before
No.
me. Right. Remember, this whole discussion is what inferences
Yes,
can the court draw? That's the night of the disappearance.
yes,
How does somebody make a mistake?
like that.
Whether you last saw your child in the morning or at lunchtime and or when you discovered your child went missing.
Indeed, my lord, and especially so if the child is allegedly sick. Indeed, my lord. Another little puzzle piece.
You prefer to work with puzzles.
Yes, my lord. I'm a picture person and I'm a puzzle person. Definitely.
Yes.
Maybe to be more concrete, I suppose. It's just to have it in hand. I have no idea.
Now, I'm just trying to, as I'm going, because I didn't see this timeline before. It was delivered this morning, just before we started. So
Yes.
I'm going through it, so I don't know what's on the next slide.
No, my lord, it will be dealt with because this is now the interview with Butta, and then the next one is the interview with Kelly on the 25th of February. So we are getting there.
So now we're going to 13. Was there not something that you missed?
I was dealing with the third last bullet from the bottom, my lord, this inclusion of the fact that she came home earlier and that they had smoked tick. And then after that, in the afternoon, they went to fill up the gas canister, again bought tick and smoked that. It is very important, and maybe I have skipped something here, but the fact that Butta, I think I definitely skipped. May I please start at the first bullet? I turned my page and I think
Are you on the last one where I asked you some clarification issues was
yes.
That was 12, but we've dealt with that now. So now we can go to 13 and start at the top.
Indeed,
of
my lord. I turned my page. I'm a concrete person, so I turned my page and I remembered I was at the last bullet. So the first one then, Butta confirms the presence of Stefano, Rens and Nilo on the day, the Monday, at his house, whilst Joshlin and Riquin were both present. He confirms that Rens sent Joshlin to go and check on her kids at her residence and later returned with Joshlin to Butta's house. Butta confirms that Riquin left to go to Brother Lowe and only returned home around 6 o'clock that evening. Rens went home not long after Riquin left to Brother Lowe. Joshlin remained home with him and Stefano. He could not account as to what happened to Nilo. He doesn't know when Nilo left. And then his explanation is that Butta and Stefano would then take turns watching Joshlin in their quest to sell this microwave and other items. They took turns looking after her. He could not explain when Joshlin disappeared. Strange. A person in care, in the parental role, in the absence of the mother, does not know when she disappears. He confirms that after Kelly arrived home from work during late afternoon, he, Stefano and Kelly went to fill up the gas canister and they went to buy some tik and they smoked that. After they were done, he and Stefano left to Stefano's house where they continued to smoke drugs, and they only returned home late evening after load shedding had already finished. He confirmed he never participated in searching for Joshlin the evening of the 19th. Kelly and the community members searched for Joshlin, but he did not. Kelly appeared, okay, so now we're dealing with the interview of Kelly on the 25th of February. Kelly appeared irritated and aggressive even before it started. She confirmed that she left Joshlin and Riquin in the care of Buta. She returned home later the morning to smoke tik with Buta. When she left home, the children remained in the care of Buta. Kelly mentioned to Captain Lombard, "Meneer, my kind is nie meer in Saldhana nie. Ek moet aangaan met my lewe. Ek het nog ander 2 kinders." Something that shocked Captain Lombard at the time. A follow-up question to her to explain how she knows that Joshlin is no longer in Saldhana, she replies, "My kind is weg." My lord, definitely that implies knowledge on her part that her child is no longer there. She's gone. That is the inference that the state requests the court to draw under the circumstances. Kelly shows no emotions and she's cold during this interview and aggressive and impatient. And when Captain Lombard asks for an additional statement to be taken, she's in a hurry because they need to get to Spur. That is more important than finding her child and assisting with the investigation. Kelly informed Captain Lombard that Joshlin has made her famous. The famous words that many witnesses testified about. She never asked for an update on investigation. She never inquired to possible new information received by the investigators at all. It was more important to get to Spur. Then the next day, the 26th of February, this is where the call happens between Michaela Daniels, her sister, and Kelly. Kelly informs Michaela that Joshlin is in the area. Someone wanted to sell her child. Iemand wou my kind verkoop het, but it is too heated in Saldhana now. But she is in the area. My kind is hier in die plakkerskamp. She then asked her a long list of questions, and Kelly just replied, "You're asking me the same questions that the police have already asked me. I know you're a policewoman, but I'm not going to answer all of those questions again." Kelly tells Michaela that, and this is important, on the 26th, as the court has just pointed to that now she informs that the reason why Joshlin and Riquin did not go to school was because of the school uniforms being dirty. And an add-on, she didn't have money to buy detergent in order to wash the clothes.
So can I just pause you?
Yes.
So on the previous day, she had the interview with Captain Lombard at Vredenburg.
Yes.
That's when I was surprised that it was put to Captain Lombard that she doesn't smoke cigarettes, because there were other evidence of other witnesses referring to her smoking,
Yes.
and it was not challenged.
Yes.
But be that as it may, she tells Captain Lombard Joshlin is no longer in Saldhana. Now remember, there's not yet a criminal case opened at that stage. It's still a missing persons inquiry. So the next day, she tells her sister that Joshlin is still in Saldhana. Yes, it was put to Ms. Daniels. There's no evidence from the defense, but it was put to Ms. Daniels. That was just a motherly instinct. But if it was your motherly instinct on the 26th and you want your child to be found, why did you not share your motherly instinct with the police on the 25th?
Indeed.
And if that question remains unanswered, what inferences can I draw from that? And if the inferences is a negative inference, how does that complete or assist in completing your puzzle, being the tactile person that you are?
Well, my Lord, definitely. Unfortunately, that is it. Once you lie, you must stick to that lie. And it's difficult because then you forget what you lied yesterday. So now you tell another lie. And it becomes all the more difficult in order to remember who you have told what. To stay consistent with those lies. My learned colleague put it to Mr. Accomplice in cross-examination, that if there's one truth, or if it's the truth, it stays the truth. There's only one truth. But once you start lying, it's difficult. I like to refer to it as that cat on the hot tin roof, where the feet, it's difficult to stand.
What we're dealing with now in the analysis, because this is what we're doing.
Yes.
We're looking at the evidence, and I'm trying to understand the evidence. Maybe on a lighter note, if we can. Because we've already been busy an hour and a quarter. Your colleague also put it to Mr. Accomplice. And this is what we're busy with now.
Yes.
The devil is in the detail.
Oh, yes. Indeed, my Lord. Definitely.
And you must just remember, the accused before me are not charged with lying.
No. Definitely not.
Because if that was so, it would have been a totally different and easy story.
No, for sure. I wish it was, but it doesn't work that way, my Lord. And we've also said, being a liar in one aspect doesn't make you a liar in everything. But unfortunately, and this is our submission, here are just too many lies. That's why, even on this aspect, something as simple as, why did my child not go to school? Or, where is my child? Is she still in Saldhana? Is she out of Saldhana? What is the position? It changes from literally the one day to the next.
Thank you. I interrupted you.
Thank you, my Lord. Yes, that brings us to the 29th of February. Stefano and Ayanda are brought into the police station. Stefano makes a statement to Constable Segobe, and both are then excused after that statement is made. It takes us to the 2nd of March. Kelly and Butta meet the minister, that was the Minister of Police then, and once again she repeats that Joshlin has made her famous. On the 3rd...
That was outside the police station to Captain Lombard when she had the green dress on.
Yes.
And her hair was blow-dried.
Yes, and when he said, Kelly, jy lyk nogal mooi, it was then that it was said, Joshlin.
That was his evidence.
Yes.
The green dress and the hair that was blown out.
Indeed, my lord, indeed. That takes us then to the prayer on the 3rd, or the ceremony on the 3rd of March. The prayer meeting was held in Saldhana. This is where Kelly then removes her beads, and she is seen dancing on stage with those.
Is she dancing on the stage or below the stage? There were 2 videos in the series of Miss Hanif. The one that you can see the person in the red dress,
Yes.
dancing. That's what was shown there.
Yes.
And she uses the next one with the beads to show it's the same person.
Yes.
Right. But if you watch that same on here,
It shouldn't read on stage. It was to the.
it was below the stage, so
stage,
that note is wrong.
Yes.
Because remember, in the last exhibit of Captain Morris, Colonel Morris, you've included the Hanif
Yes, my lord. Indeed. So
videos.
It's conceded. This shouldn't be on stage.
So
it was just.
And there one can see the dress is not pink as it's shown there, but it's more red.
Yes.
When I play it, in fact, we played it on Friday at the office on this particular screen.
It was, however, Mr. Kutsia's evidence that she was dressed in a pink outfit, and it was Ms. Hanif's evidence that she picked that pink outfit
Yeah,
for
but
that
it
day.
could be, it's a
Yeah.
darker pink. It's
Yes.
more towards red than
Yeah.
what it's shown on the
Indeed.
on that screen of yours.
Yes. Yes.
All right.
Indeed, my lord, it was Ms. Hanif's evidence that Kelly was dancing and enjoying the time there with these boys, young boys, the temple boys.
Remember, this was a prayer meeting
Yes,
or a gathering
for the child.
for the missing child, as it was known at the time.
Yes.
And it was not as if it was a gospel song, from what I could hear,
No.
where one would show certain emotions
Yes.
and with a rhythm, because that's acceptable.
Yes.
It's not an issue. It was more somebody jiving as in a
Yes.
gig.
Yes, definitely. Without a doubt. And that was Ms. Hanif's testimony, that she was having a ball of a time. She was enjoying herself at the time.
Okay.
Thank you, my lord.
The second bullet point of the 3rd of March. I can
Thanks.
see on the side of my screen, we're now on 16, it goes to 19, and 20 is just the conclusion. If you're okay with it, we can conclude this timeline and then take the break.
Thank you, my lord. Thank you. So Stephen Kutsia recognizes her there on that Sunday, and then he recalls the conversation that he had with her in August of 2023 when he met her. And that was at the time when she said that her family is terrible and that she will have people take her children away. And at first she did refer to children, plural. She's waiting for them. They have disappointed her. But even if they don't have the full 20,000 rand, she will accept 5,000 rand. Furthermore, she tells him it will happen in January or February of 2024. And this town is going to be like a movie scene. There will be lots of people and cars. People will search, but they will not find anything because the child, then it was singular, the child will be taken far away. And Mr. Kutsia was very pertinent in this testimony. My Lord, and I submit that if one considers Mr. Kutsia and just his demeanor, the way in which he testified about this, there can be no doubt as to his credibility and certainty about this testimony. He was very specific on the wording even, initially referring to children plural, later just the child will be taken far away. This bothered him so much when he made this realization that this is Kelly's child, the child that is missing, that at first he tried to report it to his wife. That didn't work. She didn't want to listen, didn't want to be involved. So he then reported it to his employer, Mrs. Creer, who immediately realizes this is too big. She first calls her husband, and then she says, this must be reported to the prosecutor, Mr. Van Zyl. And it is then reported to Mr. Van Zyl on the very same date. There's no possibility for an argument of a recent fabrication or anything like that.
And there was no evidence or any suggestion that he knew that by then Ms. Smith was already under arrest.
Not at all.
Remember, Mr. Van Zyl, I found it at that stage, of course, it was early days in the trial, so one didn't have the full picture yet. I found it strange that he said, well, we didn't follow anything up because it was known to us. So him being the control prosecutor in Vredenburg, it was obviously known to him that Ms. Smith is already in custody.
Yes, it was known.
Because she was going to appear the next day.
Indeed.
In court.
But Mr.
Coetzee didn't know. There's no suggestion that he would have known.
Not at all. Not at all, my lord. Brigadier Hanana or Captain Lombard then gives an instruction that these 3 people must be brought in to be re-interviewed the next day, the 4th of March, which then leads us to the 4th of March. At first, there's a massive police action. It involves the city of Cape Town, uniformed members, surrounding stations, community, sea border, LCRC, K9 unit, everybody that could possibly be involved was involved in this search. My lord, I pause there just for a second, and this is just on the probabilities. Colonel Sebola's testimony was that he specifically, the team that he was the head of, remember that the whole area was divided into sectors and teams, and then each team had a leader, and he was the leader of his team. His team actually searched the Jacobs Bay area. And it's Mr. Van Ryn's contention that he was taken to the Jacobs Bay area on that very day to be tortured. What is the probability that that could have happened? Colonel Sebola and his team was specifically searching the Jacobs Bay area. I'm just adding that in there. Right. Between 4:30 and...
I think we missed it in the trial within a trial.
My lord, I was keeping that for the cross-examination.
Well, you were cross-examining.
No, my lord, I mean specifically for the main trial.
Oh, you were keeping it for the main trial.
Yes, that's why that's why I've thought about this a long time ago, specifically looking after that, and I neglected to insert it in the timeline. But
Shame you didn't have the opportunity to play your trump card. Yes.
Be that as it may, my lord. Between 4:30 and 5 o'clock, Captain Lombard arrives at the Seaborder FCS unit. Stefano, Kelly and Buta were already there at the time. Owen is also there. This is his first meeting with Owen, where he then shares information, and that information is immediately followed up, but it is negative. It doesn't take us anywhere further. Then at 10 p.m., now the interviews officially start with Stefano and Buta. And first they say that the police must ask Kelly. This was the first revelation, first by Stefano and then by Buta. Then Stefano mentions Makalimo, the name of Makalimo. Buta confirms the name of Makalimo.
In this timeline, you write it Makalimo at some places. I thought it was Makalima.
My Lord, in the...
That's the nickname.
They are used interchangeably. I think, if I'm not mistaken, in the statement of Mr. van Rijn, it's also referred to as Makalimo with an O and not an A. But it's the mother of the child. That's where the Maka comes from.
I figured as much, because remember, there was the statement put to Laurentia Lombard that Miss Smith was teaching one of the children
Afrikaans. Yes.
Afrikaans.
Yes.
And I thought, I tried to decipher my notes because the name of the child was mentioned.
I know what the name is. May I say that? Atandiwe Mkiba. It's another child. That's the child who came looking and received the Afrikaans lessons.
So I also thought that because she has small children, she's got a daughter and a son, that I know from the trial within the trial evidence.
Yes.
And I was wondering whether one of her children's name is most probably Lima, or shortened for Lima, and that's why she's called Makalima. That's the stuff, thinking about it.
Yes, my Lord. Well, it could also be, because people pronounce it differently, it can be Lima, Limo. It can be any one of the two.
I just noticed the spelling here, because when I took notes, as we were going through the evidence, I was writing Makalima. And I thought I had seen it in one of the exhibits with an A, but it's of no moment.
No,
we know her name is Pumza.
Yes, indeed, my Lord.
Her first name.
Indeed.
So.
Indeed, my Lord. So at 10 p.m., the interviews with Stefano and Buddha commence. First, they say that the police must ask Kelly. Then Stefano mentions Makalima. Buddha confirms. The police mobilize once again and proceed to Makalima's house at 11 p.m. Makalima and her husband and the two children are then brought into the offices, and she is questioned. On the 5th of March, investigation group interview Makalima. Her version of the events is different to that of Stefano's. Stefano and Buddha confronted with the different versions provided by Makalima. Both Stefano and Buddha indicated that they want to tell the truth and opted to provide statements to the police. All placed under arrest and served with their SAP 14As. Both are taken for pre-confession medical examinations. Stefano appears before Colonel Clark on the 5th of March for the obtaining of his statement. Colonel Clark stops the process. Stefano is given a chance to eat, to take his pain tablets, and to sleep. Later the same day, he is taken to Captain Siekwe. Both the incidents are recorded, Exhibit 2 and 3. Then Buddha appeared before Lieutenant Colonel Pretorius. His statement is obtained, Exhibit 4, and then both were taken for pre-confession. That's a repetition. Both of them were taken for pre-confession medical examinations, and Stefano was indeed taken twice, once to Dr. Nell, other time to Dr. Zimri. On the 7th of March, both Buddha, Stefano, Kelly and Pumza make their first appearance in court. All the accused abandoned their bail applications. All accused were represented by LASA, and there were no complaints of any assaults by any of the accused in court, and none of them opened any cases. On the 13th of March, the charges are withdrawn against Pumza. The interview with Renz happens and she's detained. The interview with Ayanda happens and he's excused. On the 15th of March, Renz makes a confession to Captain Sillier. It's recorded, and that's Exhibit 1. On the 18th of March, Renz makes her first appearance. On the 21st of October, the charges are withdrawn against Renz. She signs her 204 statement with Advocate van Tonder, who was instructed by LASA to represent her throughout this process. My Lord, is this perhaps an opportune time, as what we will deal with hereafter is the corroboration that we find and submit to be corroboration
right.
for them?
It's 11:30. We'll take the adjournment till 11:45, 15 minutes, and then we plan from there.
As the court pleases.
The court will adjourn.
All right.
Thank you, Ms. Sonnepoel.
As the court pleases, my lord. As indicated, and in following then the directions of the case law that we do have, in order to assist this court, in order to come to the realization whether there is reliability in Ms. Lombard's evidence, that it is reliable enough to can be regarded as trustworthy, we, from our side, look at possible corroboration for her version. And that is where this mind map comes in. My lord, it is based on my heads of argument on page 45 and further on. So what's on the mind map is just a picture and an abbreviation of what is contained here, but there are also extra add-ons that I will deal with later.
Okay, let me just...
So if I may just
Just one moment. Okay. I've got it open enough. In a nice 150% of what you have it there, so I can see what's going on. Good.
My lord, just for an explanation, I know these, I refer to them as spinnekoppe, but these things, if you look at it the first time, one doesn't know where to start. So we actually, from the center, was Laurentia Lombard, then to find the corroboration, and we numbered them similar to the numbers in the heads of argument. So that's why it goes to, from the right-hand side, up to 5.1. And then it goes to 5.2, where there is then an interlinking of those two, it comes down. But then it goes, so it starts at the top on the right-hand side, it goes down all the way to the left side in a circle formation. To the left-hand side then, and then the last ones are the, if I may say, the add-ons. That's not specifically in the heads, so they are not numbered on the left-hand side in the top. So it's a clockwise.
So those are the light blue on my, you've got the numbered ones that makes reference to the heads of argument.
That's indeed.
And then there are the add-ons on that.
On the left-hand side to the top, yes, my lord. So clockwise from the right-hand side and the top, all the way around. Those are the numbered ones, and then the unnumbered ones, left side top. And it is difficult to, because it's quite a big thing, and it's small print, it's difficult to see. So we also focus on portions, so that's the reason why I'm just explaining.
That's fine with me.
Thank you.
I see all the defense counsel also has theirs open, because what we're going to deal with now are those, as I understand the heads of argument in your chapter 5 on page 45, and with this in mind is where you want to show me the corroboration that will provide the warranty for the reliability.
Yes.
In a nutshell.
Indeed. Indeed, my lord.
The authorities uses different terminology for it, but that's just to put it in layman's terms. In Afrikaans, waarborge vir betrouwbaarheid.
Indeed. Indeed, my lord. And some of them may be as light as a feather, but some of them may have more weight to them. So we try to look at all of them, and I'm sure that there will be others that we missed, and I'm sure that there will be some that the defense can argue is not enough corroboration, but this is what we submit to be the corroboration, my Lord. Thank you. So, for us, the most reliable and most important corroboration for Ms. Lombard's testimony.
Just give me a moment, I just want to take out different color pens. I'm going to do both this evening and tomorrow. I will work on the screen, but I brought my trusty tool, so it's always with me in court.
Always wise. Thank you, my Lord.
So I'm going to, this is not an exhibit before the court.
No.
But I will place it in the court file afterwards.
Please.
So if I mark the line with green, it means a submission is made, that's a strong line. If I mark the line in red, the submission is, it's arguable. But the state still submits. It's a line to be followed.
Indeed.
And when the defense will argue, I will use a different color pen, and I will indicate where they argue that the line is broken.
Yes.
But it will be on the court file, just so that it's a guide.
As the court pleases, my Lord, and just for record purposes, my colleague did, in fact, send this electronically to Counsel for Defence, so they do have it.
I can see
and
they also
if they wish to make use of it later, then it is there. And I've
opened it up from our team, so all the documents that came in, we've uploaded on the team, and it's sitting there. So I actually opened it up from there.
Thank you, my Lord.
And it's under that Erasmus J tile that you will find it, and it's then under Polis. Yes.
Maybe I should have spectacles. My Lord, so as I was saying, we submit that the most important corroboration for Ms. Lombard's testimony is in fact that of Mr. Kutsia. And it deals with so much detail in this narrative that she in fact told him as early as August 2023 already. The plan, the detail thereof, the date thereof, that it will be in January or February 2024, the amount involved, because specifically she said, if they don't have the full 20,000 rand, she'll even accept the 5,000 rand. And then also the result that it would have in the Middelbos, Saldhana area. There would be people and cars, and it would be like a movie scene. Then secondly, the fact that Mr. Kutsia specifically refers to 20,000 rand. My Lord, this is of great importance. Ms. Lombard's testimony is that she overhears when Kelly tells Boeta, hier is die geld wat ek by die Songoma gekry het. He asks, how much is it? And she answers, it's 20,000 rand. Mr. Kutsia also refers to this 20,000 rand. That's what Kelly told him. It's the testimony of Rens. It's the testimony of both the accused, in KK and JJ. And that's why at this stage I moved to 519 and 520. That's why in the mind map it actually refers. So it's 5.1, 5.2, 519 and 520. Because in 519, Exhibit KK also refers to 20,000 rand, and when asked, so wat is die 20,000 rand voor? The answer is vir verruiling vir die kind, meneer, for exchange of the child. This is the specific words that's used in that statement. Then in 5.20...
Can you just pause there? So on that point, I just want to understand it. Rence's evidence is, and she was consistent about the amount of money.
Yes.
The 20,000 and the purpose for which the 20,000 rand would be paid, that would then relate back to where we started this morning with the definitions in the Act.
Yes.
Right.
Yes.
So the reliability support that she finds is in Mr. Coetzee's evidence, relating back to something Ms. Smith had said in August of the previous year, but more recent in time, the exhibits KK and JJ, which are the statements made by Mr. Apollos and Mr. Van Ryn.
Indeed.
And you say that concludes a green line.
Yes, indeed.
On its own.
A solid green line, my lord. I'm getting assistance here from the side. A solid green line.
I have a fine liner, so can't. And I do it freehand. No, I'm repeating it because I want to understand the submission, but also so that the three accused understands the submission.
Indeed.
Because I'm sure it's going to be challenged on different grounds.
Yes, no, definitely, my lord. So that is just that portion that KK refers to 20,000 rand as verruiling vir die kind in exchange for the child, that transaction. But then also in KK, still in 5.20 of my heads, on page 20 of 26, when the question is posed if they sold the child, this question is not denied. It's never said, no, we didn't sell the child. It says, nie ons nie, meneer. Kelly en Makalimo. Hulle het gepraat. So, knowing that there was this sale, but it was them. It's just not us. It's Kelly and Makalimo. This is what we find in KK. Hulle het gepraat. But then on page 21, he indicates that he does not know what his cut. He's definitely going to get a cut, but he doesn't know what the cut would have been. But that accused 3, Kelly, had already spoken to Stefano about it. Now, my lord, one needs to stop here and just think about this. What are the probabilities that Boeta, who's in a relationship with Kelly, it would not have been discussed with him, but it will be discussed with Stefano, how much money he was going to get. That's in direct contrast to what Ren says. Ren says, we were told, you getting 1,000, you getting 1,200. We both accepted the offer. And we knew why we were getting that. It's for our silence, and we need to play along. So one has to ask the question, If Ren says, you, Stefano, would be getting 1,200 rand because that's what Kelly said, then the question arises, so later on, in that very same statement, Stefano says, I went for my cut, the 5,000 rand that I wanted to collect there from Makalimo. So was there more in-depth discussion between Kelly and Stefano? Did he know more? Did he have anything more to do? Why would he be getting that 5,000? And the 5,000, and it's very important, my lord, there's no way that that came from the police. In his testimony himself, he said, that came from me. But if, for argument's sake, it were to be argued that this is all the police's story, as it is alleged, then one would definitely want to see it in the document. But it's not contained in the document.
Well, but...
the 5,000 rand.
But can that be argued? Isn't that water under the bridge? Isn't that what I determined in the trial within a trial?
No, my lord, no, definitely. All I'm saying is that lends corroboration, but it also indicates the knowledge, the necessary knowledge of the fact that there was this transaction and that we know we are going to get money from it.
Is there corroboration to be found on this line? I'm just talking about this line now. In the speculation that Mr. Van Ryn had on the 22nd in the presence of Sergeant Milstein. Remember, Sergeant Milstein went to his house.
Yes.
He was then talking to other people. That was the day that Sergeant Milstein formed the opinion that he was as high as a kite.
Yes.
And he wasn't going to engage him further.
Yes.
But then he spoke. He was speculating.
Yes.
So he said. Remember later on in the statement of the 29th, refers to the speculation as well.
Yes.
About the disposal of Joshlin as an item.
Yes.
And I use the words deliberately, because that takes you to the definition section of the Act.
Yes.
Is there any corroboration to be found in that speculation of his that will strengthen the chain in Rens's evidence, or does that take it too far?
Oh, my lord, I would like to, and I think it is here, but the fact that Stefano was the first person to mention that Joshlin might have been sold to a Sangoma for Muti purposes. He was the first one.
No, that was on the 22nd of February.
Yes.
That was the day that Sergeant Milstein attended at 8 Arend Street.
Yes.
And there were other members of the community there, and he was engaging with other people. And Milstein's evidence is clear. I didn't want to, because I could see he's a bit on edge, and yeah.
Yes. No, definitely, my lord. But what I'm trying to say is that supports or gives corroboration for the fact that Rens says this was the plan. And she sees the woman who looks like a Sangoma, and she hears Kelly telling Buta, this is the money that I've just received from the Sangoma. It's 20,000 rand. That is the argument, my lord, that all of this corroborates Rens's version in this respect. Okay.
Yep.
Then, if I may go to 5.3, I'll get there now. The social media video of accused number 2 where he specifically says that accused 1 and Rens smoked a quarter of a half Mandrax tablet that morning in the house. Now, my Lord, the evidence is that Rens received that quarter of a half Mandrax tablet. And
For the bag.
For the bag, for the sling bag. And then confirmation for that in that social media video where he refers to it was a quarter of a half Mandrax tablet that they smoked. 5.4. According to her, accused number 2 had a microwave, a hair tong, and an electric cord to sell, but left with the microwave to a potential buyer. Now we find confirmation for this fact in Exhibit JJ, where accused number 2 then confirms that he indeed have a microwave and that he sold it on that day. He still had to go back to collect the 100 rand later. That's also consistent with accused number 1's version in Exhibit KK, where he also speaks of the microwave that they wanted to sell or sold on that specific day. So for this aspect, and I think that's where that of the feather comes in. It might sound like little, but it's actually confirmed in different documents by the 2 different accused. Corroboration for.
On the 5th of March, remember by then, Rens didn't say anything about the microwave.
Nothing.
On the 5th of March, both Mr. Accomplice and Mr. Van Ryn speaks of the microwave
Yes.
in the statements that they made,
Yes.
Exhibit JJ and Exhibit KK. Clearly, even if the evidence was a little bit credible and reliable, even if it was, it didn't come from the police.
No.
So it came from them.
Yes.
Rens only get arrested a week later,
Yes.
more than a week later,
Yes. 10 days.
and that comes up.
Yes. Indeed, my Lord. And when we were at the inspection in Loco, we pointed to.
Just one moment. I'm going to get there. It speaks of the interactions between Rens, Mr. Accomplice and Mr. Van Ryn during the course of that day, which is much more than merely coming around and asking for a cigarette.
For sure. Definitely.
And that again links up with the social media interview of Mr. Van Ryn. Remember, what you want to do here is forget about your jigsaw puzzle or my mosaic. If you look at this mind map, right, the way I visualize it, you're going to have these lines, and then on the outer perimeter, you're going to link them like chain links.
Yes.
And it will be, that chain is complete. Cadre question. So you take those, and I don't like to look at them in isolation, but to see how they overlap. Okay, so that's the issue with the Rens, and that's the third issue where there's corroboration for the 204 witness also being a single witness.
Indeed, my Lord.
Right,
Indeed.
I'm with you, thank you.
Oh, yes. And of course, on the mind map, my lord, this was also confirmed by Buddha to Captain Lombard during the interview on the 25th. That indeed, they did sell that microwave that day. Which then brings me to 5.4. No, that was 5.4. Sorry.
You're going to 5.5.
5.5.
So that's the 5.5 seems to be
according to
the events of the Sunday.
Indeed, my lord. That during the interview that he had with accused number 1 and number 3 on the 25th, the version accused number 1 provided to him about what happened on the Sunday and the Monday corresponds largely to Ms. Lombard's version. And as the court has just correctly pointed out, it's much more than just coming around and asking for a cigarette. There was lots of activity happening on those 2 days, and in broad terms, everything is confirmed by accused number 1 and 3 as to what happened on that day. Then 5.
But there's also in that regard support for her evidence by Paulina that was on her way to the hairdresser.
Yes, indeed, my lord, for the argument that happened there.
Just in broad strokes about placing her there, about placing Rens there. Mm-hmm. What Rens overheard, that's a different issue.
Yes.
Okay, now I'm with you.
Indeed, my lord. Then 5.6, if we move to that one, the fact that neither accused 1 nor 2 participated in the search of Joshlin that Monday night when Joshlin went missing confirms that they knew what happened to her and that a search would be a futile exercise. The same, of course, holds true for accused number 3 and Miss Lombard for what happened then thereafter. None of them participated in any search because they knew Joshlin was not going to be found. This lends corroboration for Rens's version that Joshlin was in fact sold, handed over, put in the polo and taken away, never to be seen again. 5.7, Constable Gongota and Kobese, that's Constable and Sergeant, confirm their visit to her home late that night, and the fact that it was accused 1, 3, and Nilo who were present with them, and that Ayanda scolded them for bringing the police to his home. Confirmation for what Rens said. (5.8) She narrated that they were transported by members of the police to Cape Town for their own safety. And here comes Brigadier Hanana, and in cross-examination he's asked about it, and he confirms that yes, indeed, that was authorized by the police. It was necessary for their safety to take them away. That's why the police did, in fact, transport them. This is independent corroboration for the version of Rens, my lord.
And at that stage, Rens is not a suspect?
Not at all. Not at all. Then 5.9, accused 1 did not initially mention accused 2's name as a person who was present with him on the Monday. It's only Miss Lombard that mentioned accused number 2's name. Similarly also, Kelly does not mention Stefano being there in her affidavit.
Wait, I'm trying to find your 5.9 here.
Is it not there? Okay. My Lord, that appears to have been an omission. We did not, my apologies, it's an omission, it's not on the mind map, but please, it is relevant and we submit it is.
Is it on your one that you have?
No, my Lord, it was missed.
Yeah, but so overnight you can just give me an updated one.
We will, definitely. No problem, my Lord. We will definitely do that.
But that's, you've also mentioned it earlier.
Yes.
That for the first day at least, both Ms. Smith and Mr. Apollos
Did not
kept
mention.
Mr. Van Ryn's name out of their mouths.
Indeed, my Lord, and that's why I earlier referred to, one definitely gets the idea that this is an interlinked, it's a friendship, close-knit friendship, and they try to keep him out of this. Rens, on the other hand, my Lord, does not have any loyalty towards accused number 2. Her testimony is, I knew him, he was a friend to Buta and Kelly, but the two of us didn't sit along the same fire. We were not friends. So that's why Rens is the one who mentions accused number 2. Accused number 1 and 3 don't mention him initially. When Rens mentions him, it's then confirmed and corroborated later by themselves of having been there. That accused number 2 was indeed there, the Sunday and the Monday. .10. Accused number 2 was the first to speculate about the possibility that Joshlin could have been sold to a Sangoma for Muti. He, although, suspected Miss Lombard and Ayanda to have been involved. It then later on conspires, my Lord.
I'm with you.
When we get the evidence of Miss Lombard that indeed Joshlin was sold to a Sangoma, but it's got nothing to do with Ayanda and Rens. But accused number 2 was the first person to mention the possibility of a Sangoma and Muti purposes being involved on that 22nd in his house. 5.11. 5.11, Colin Zegers confirms that accused 3 left around 12 o'clock, just after 12, returned and left again just before 2 o'clock, and then stayed away for a longer period than was expected, between 30 to 45 minutes. These times fit in with what Rens says. My Lord, we need to remember that Rens' testimony is, the morning already it was said, keep Joshlin ready for around 2 o'clock because that's when I need to give it to the people. And now Colin Zegers confirms, corroborates this time aspect for when Kelly actually said, I'm going home in that lunchtime and staying away longer.
It also fits in with what Ms. Smith herself told Sergeant Kubese on the night of the 19th.
Yes.
She mentioned the time 13:50.
Yes.
Remember, I took you there earlier,
Yes.
because that time is then omitted in the warning statement.
Yes.
That's
Indeed.
also the time that she told Sergeant Kubese was the time that she noticed for the first time that Joshlin wasn't there.
Yes. Indeed, my Lord. Indeed. 5.12, accused number 3 tells her sister Miss Daniels on the 26th of February that Joshlin is still in Saldhana and that someone wanted to sell her child, but it is too heated in Saldhana now. This confirms a sale or a prospective sale of Joshlin, and that she knows where Joshlin is. We find that to be corroboration for Renz's version. And of course it was also confirmed in the interview of the 25th of February. Kelly informed Captain Lombard that Joshlin is no longer in Saldhana. Then 5.13. Why would accused number 3 lie to Kelly Zegers by saying that accused number 1...
Just one moment. Do I miss something on this printed page? Because on the printed page you gave me, because I'm not going to look at the screen now. My one jumps from, it doesn't have a 9 and 10. Now you're at 11 and 12 we've dealt with. You want to go to 13, but I don't have a 13. The next number I have is 17, 18 and 22. But maybe if you tell me which event it is, it might just not be numbered on my one.
Yes, my lord, it appears that maybe last night, in the very late hours or early morning hours this morning, that there might have been an error, perhaps, but we will correct that.
But you see, I've got a lot of, on the left-hand side, I have quite a number of items that's not numbered. So maybe if you tell me which of the items it is, it might be on this mind map, that it's just not numbered, then I can just write in the number.
Yeah, my lord, I will...
Number 13 would have been what event?
The 13 would be that accused number 1 was also searching for Joshlin that night of the 19th. That is what accused number 3 tells Kelly Zegers when she comes to her that night. She says accused number 1 is also searching for Joshlin, whilst he never searched for her. And that's his version itself. Accused number 3 told Gongota and Kobese that she did not know where accused number 1 was when she came home. It wasn't only Joshlin that was missing, it was Buta also. Both of them were missing. And the 3 of them then go looking for Buta until they eventually find him in Talmaki Street, after Nilo pointed them to Talmaki's street.
Now you will recall that it was put to the witnesses that they're lying about that.
Yes.
That he wasn't at home.
Indeed.
And then he said it himself in his statement.
Indeed. And that he spent the night there smoking with his friends before he returned home. Indeed, my lord. Takes me to 5.14. Kelly Zegers formed the impression that accused number 3's behaviors, that she was protecting someone. Sorry, I see that's a spelling error. I apologize, my lord. Behaviors should have an R in it. My apologies, it's 5.14 of my heads.
Trying to find...
I missed the R. But Kelly Zegers forms that impression that accused number 3, from her behavior, she's protecting someone. It's not only Kelly that forms that impression, it's also Miss Hanif that forms that impression. She also expressed that accused number 3 became defensive and aggressive the minute that she mentioned Buddha and questioned whether Buddha could possibly be involved. Then Kelly became aggressive and defensive. She even left the live call, which we could see on Exhibit 5. By the mere mention of Buddha's name, she left. That was the end of her presence there.
Now, remember we're dealing with Laurentia Lombard now.
Yes.
How does that fit in with her evidence?
My Lord, if you will just give me a second. If I come to 5.16, I'm going to close the three together. 5.16, it's strange that accused 3 would find it necessary to report this call from a Nigerian male to Miss Mart, and specifically then adds, remember that Buddha is not guilty. Miss Mart doesn't even know Buddha. Why is it necessary for her to convince people that accused 1 is not guilty? Why does she need to protect him? So now we've got 3 independent women that all form the impression that Kelly is protecting Buddha. Now, my Lord, my submission is, Kelly was protecting Buddha because she was actually shielding. And this is my submission, and this is what we argue, and for the court to infer, that she was scared that Buddha would spill the beans. That's why she's protecting Buddha. That's why she is continuously keeping him away, and she's the one doing the talking. She's the mouthpiece, the mondstuk was the evidence that we heard here. And isn't that exactly what happened at the end? Now, my Lord, to draw that back to, and that was your question with respect, to Laurentia Lombard's evidence, that's the evidence. All 4 of us were in on it. All 4 of us knew that this is the plan, this is the transaction, and we are going to be paid for our silence. But Kelly was concerned about Buddha, and she's forever shielding him that nobody must think he is guilty. If I might take it one step further, my Lord, if we consider the evidence of the 4th and the 5th of March, she's the one who continuously wants to go up, to go to Buddha, to be with Buddha, to see what is happening there. It's all because she's scared that this plan and agreement that they had is going to be spilled. The beans will be spilled. So she's protecting Buddha, but in effect, my Lord, the submission is she's also protecting herself. Because the minute that any one of the 4 speak about what they had decided to do and spill the beans, she's also going to be in trouble. So that is the argument, my Lord, and that's why I submit that there, that if one considers 5.14 to 5.16, those 3, then that is our submission. That she was indeed protecting him, but in fact protecting herself. I hope that answers.
Yeah.
Thank you, my Lord. Then 5.17, Paulina Chosa, who witnessed that argument that night and the event that happened there. Yeah, 5.17 is on the mind map again.
Yeah, we've already spoken about that earlier.
Yes, thank you, my Lord. I just made an extra note here that it's important to remember that Lombard's testimony was that they had an abusive relationship. That's also confirmed by Ms. Mbombo's evidence in her report and in her testimony, and then also by Natasha Andrews, and also by Colin Zegers. So there's lots of confirmation, corroboration for the fact that this was indeed an abusive relationship, not a happy life. Happy wife, happy life, they say. 5.18, my Lord. In Exhibit KK, accused number 1 narrates on page 16 of 26 the reasons why accused number 3 had problems with the family and the interference from Natasha Andrews providing a motive for why she would sell Joshlin. This also ties in with what Mr. Kutsia testified earlier about accused number 3 referring to her terrible family. When Captain Lombard told accused number 3 that accused 1 and 2 says they must ask her what happened to Joshlin, she also started blaming the family for the position in which she was then. Blaming others, but specifically the family. This corroborates what Miss Lombard said about this relationship that they had, and Mr. Kutsia's testimony is very important in that regard. 5.19, I've dealt with. 20, I've dealt with. 21. It was put to Sergeant Fortuyn that part of the prescribed story, accused number 2 had to tell the officer was that there was a man with a, and this is a very important one, that there was a man with a red T-shirt at Makalima's house. The time when they were sent to Makalima's house, that there was indeed a man with a red T-shirt at Makalima's house. But then in Exhibit JJ, and specifically the video and the transcript that we have there of 3 and 3A, he tells, and that should not be Pretorius, my apologies, that should be Captain Siekwe, my apologies, that accused number 3 has asked him the next day if he had not seen a man with a red T-shirt, and that a man with a red T-shirt had allegedly taken Joshlin. When he is asked if he had seen anyone else at Makalima's house, he answers, no, he only saw Makalima. He accepted that the children must have been sleeping at the time. So, a very important part of this prescribed story that he is given to tell the officer is that when you arrive there at Makalima's house, there must be a man with a red T-shirt. Why the man with a red T-shirt, nobody knows.
How does it fit in with Laurentia Lombard? Remember, we're supposed to deal now with Laurentia Lombard and where we will find evidence
my Lord,
that corroborate her version and will support the reliability.
My Lord.
So what does what Mr. Van Ryn says about Makalima's children have to do with it?
No, my Lord. The point is only that it confirms the fact that there was a transaction.
In the bigger scheme of things, those are all circumstantial evidence.
Yes.
That can stack up against the 3 accused. I thought we were just going to deal with Laurentia Lombard now. For now.
My Lord, what I'm trying to do is, by looking at all the other evidence, the corroboration for Laurentia Lombard's testimony.
But this doesn't corroborate Laurentia Lombard's testimony. She said nothing about the Makalima story.
No, she didn't, my Lord, but she did say that Joshlin was sold.
No, that's fine.
And that's the only point. That's the only point. .22 in Exhibit JJ and the same exhibit, accused number 2 explains that he returned to Makalima's house, and I've dealt with this, to go and get his cut, and that he then himself, from his own accord, says he's the one who then said 5,000 rand. And I've dealt with the fact that our argument is that that could not have come from the police. That's impossible. That was himself. That was what he said.
It's the point not simply put. Laurentia Lombard says he was going to share
Yes.
in the proceeds.
Yes.
He confirms that.
indeed, that he was going to share and that he went there to collect his cut. Similarly, accused number 1 also said that he didn't know how much he was going to get, but there had been a discussion about it, my Lord. Then I would like to just also deal with the ones in the map that are the add-ons. So Rens sent Joshlin to check on, this is part of what was argued earlier about what happened on the 19th and the 20th, but Rens sent Joshlin to check on the kids at her home and returned with Joshlin and her children to the house of Buddha. Now that is confirmed on the 25th of February when Buddha confirms to Captain Lombard that Rens returned to their house with Joshlin and her children, so that is a confirmation or corroboration thereof. Then Stefano's presence at Buddha's house during the morning, Buddha confirms to Captain Lombard. Also, Kelly left Joshlin and Requin in the care of Buddha. Buddha informed Captain Lombard thereof on the 25th of February. It's also confirmed by Buddha in his evidence. Then also the 19th of February, that morning, Kelly left home earlier than usual. Buddha confirms that she left early, and Carlin Zegers confirms that Kelly indeed arrived earlier than she usually does. Kelly goes to Rens's house early evening and asks for Joshlin. The commencement of the initial search for Joshlin starts. Nampla confirms the early evening search. And lastly, the police detective's visit, confirmed by Buddha, and Buddha informed Captain Lombard about this visit during the interview on the 25th of February. My Lord, that in essence are the points of evidence that we find to be corroboration, and we submit to be corroboration for Rens's evidence.
I understand that, but now let's... So what you're asking me to find is that Rens's evidence must be accepted, that as she testified, that A, there was the agreement, so there's no issue where there's a divergence between what's in the statements admitted and hers. That's there. But the mechanics, she testifies that she saw Miss Smith take Joshlin to the White Polo. Yes. Their statement says, no, we took her to Makalima. How do I deal with that?
My Lord, we have been arguing specifically that between us for a very long time. The bottom line at the end of the day remains the same. Joshlin was in fact sold.
Is it possible on the state submissions for the court to find, yes, there was the agreement to sell Joshlin,
yes,
and all of them bought into it. They were going to share in the proceeds. But insofar as it relates to the handing over at the car, she's a single witness. There's no independent corroboration for that.
yes.
But there's no need to make a factual finding about that.
Indeed.
Is it possible for the court to argue that way?
My Lord, that is exactly our argument. That it's neither here nor there. Whether Joshlin was put in the polo or whether Joshlin was handed over, Joshlin was handed over. There had been an agreement for the sale of Joshlin, and she was in fact delivered, handed over. That's all that is necessary. And then I come back to, if the court finds enough corroboration for Renz's evidence, then that should be the accepted version. Remember that the statements that accused 1 and 2 made to those officers, that wasn't adduced for the truth of the contents thereof. That was what they said to the police officers. It doesn't mean that portions thereof is not true. The court can look at all of that and find those pieces that is necessary and discard the rest. Whether Joshlin was taken, in other words, whether Joshlin was taken to Makalima's house or not, that's not the issue. The issue was there was agreement that Joshlin was going to be sold. They bought into this transaction, and she was in fact delivered and is still gone.
Is it not a difficulty that the state has if I have to accept Ms. Lombard's evidence about the car? And yes, she's a single witness, as I've indicated.
Yes.
And yes, there's no corroboration for that version.
Yes.
So, if I can't find that beyond a reasonable doubt, then we're sitting with the discussion on the Sunday.
Yes.
And the reason for the action to be taken.
Yes.
By the actions during the day of the 19th and thereafter, inferences can be drawn about complicity.
Yes.
Mr. Van Ryn says that I was merely asked to go with on the 19th. But I went back to ask for my cut. Now, he is not saying in the statement that I was unaware what the deal was. He's just saying I went with. Can I then infer, but then you must have been aware of what the deal was and what's going to play out.
Definitely, my lord.
On inferential reasoning.
Yes, and definitely also because when he is asked, what is that money for? It's for the vermisting van Joshlin. That's the specific word.
So, and can the two different scenarios, can they coexist or not?
They can.
On what basis?
That there was an agreement of sale that everybody agreed to, and the consequences thereof. That transaction happened. She was sold. We only need the soul.
You see, insofar as it relates to Mr. Apollos and Mr. Van Ryn, that version, they've given a version. On that version, it can be argued that it's sufficient given the surrounding evidence that's available. Right? But that's not admissible against Mrs. Smith.
Yes.
And it can't be used against her.
No.
Obviously, at the 174 stage, I haven't decided on Ms. Lombard. Ms. Lombard's evidence was there. And it doesn't mean that should I then find that, yes, there's not sufficient reliable evidence on the polo and the woman with the green dress, but supported enough on what happened that Sunday evening and afternoon, the discussion that took place, and that Joshlin was then delivered on the version of the other two accused, the discussion that Miss Lombard had with Miss Smith afterwards,
Yes.
and then conduct and statements that's admissible evidence, and then she gets snagged by that same wire.
Yes. And my,
That's summarizing.
and may I just also add in there, my lord, also coupled with the evidence of Mr. Kutsia.
No.
That is very important, specifically with regards to the fact that it's Kelly that had the conversation.
Obviously, you're going to wrap up
Yes.
after lunch, or do you want? How long do you still need?
No, my lord, I'm about done. I'm almost done.
You're almost done.
Yes.
Except you can deal with the judgment I've referred you to in reply.
Thank you, my lord.
Because I'm sure your colleague would have had a quick look at it. But if you, as a starting point, I'm not going to ask if counsel for the defense want to quote cases to me. They can feel free to do so. I'm talking about these old authorities,
Yes.
because it's trite of how to deal with circumstantial evidence. They're going to take me to deal with credibility issues on Laurentia, and they're entitled to do that.
Yes.
But I am going to engage defense counsel on probabilities.
Yes.
And I am going to take them not to Rex versus Blom, but we can go there too. Right? And they will take me to pages 202 and 203 of that judgment. Because in the old days, before we had paragraph numbers, I don't know why the stuff always went from the one page to the other.
Yeah.
I think it's 1936.
Is it 36 or 38?
Judgment starts on page 188. But we can go there, but we've got recent appellate division judgments on that.
No, indeed.
And the two that stand out is the ones that I've dealt with, but you can deal with that in reply.
I would really appreciate that, my lord. Yes, my colleague has made arrangements, and
so
we have
one last
received,
issue that you've raised in your heads of argument as well is because you've got two charges.
Yes.
You're asking for a conviction on the main count,
Yes.
right? And then count 2 is the kidnapping charge. Now the one is a statutory offense, and the other one is a common law offense.
May I address you on that?
You know what I'm going to ask you.
Whether it's a duplication of convictions. No, my lord, that's why I specifically submit, but may I just explain why I say it's not a duplication of convictions? It's different offences, different elements, different facts to prove the different elements. Coupled with that, our courts, okay, so let's just look at kidnapping. So the kidnapping itself, when one looks at the bigger picture of trafficking in persons, then kidnapping is but one of the possible means that can be used. So it's not the action, it's the means. But if, and just to take it one step further, my lord, so the kidnapping can only be one of the means in order to, so it's not the action, it's the different element, the one that we don't even need. But if one considers the authorities on trafficking in persons, and I'll refer to the very well-known Jezile matter, which was here and went on appeal and was confirmed. My lord, trafficking in persons as well as rape count. I've referred the Honourable Court to my matter, the Ngasana matter, similar thing.
Yeah, but,
trafficking in persons and rape.
So what do you need, what are the elements for the kidnapping offence?
The unlawful intentional deprivation of the
liberty.
Freedom of movement of the person. Joshlin.
So the facts, the facts upon which you rely for a conviction on count 2 are the same facts.
Yes.
Except you arguing it makes out a separate offence because the elements are different.
That's all.
And is the deprivation of the freedom of movement and liberty, it can be an element
Yes.
of the main charge,
Yes.
but there you're relying in layman's terms, selling the child.
Yes, indeed.
And then you go back to the definition of slavery, the broader definition in the Act.
And the fact that she's placed in the position of being a slave means that she is, per definition, deprived of a freedom of movement. She no longer is free to move around.
But isn't that can't it be argued then that it's a duplication of convictions if you are convicted?
My Lord, that was specifically one of the points that was taken on the Joshlin matter, and I'm sorry I'm going back to that, the rape and the trafficking in persons for sexual exploitation purposes. There the court specifically looked at it and found that although it was for sexual exploitation purposes, which would encompass, because sexual exploitation is defined in the Sexual Offences Related Matters Amendment Act as including rape. So one would actually say that it is encompassed, but there the appellate division found that no, it's two separate offences because of the elements of those
Now
offences.
I will go and have a look at the Joshlin case overnight, at least before Friday.
And my Lord, as I say, even in the Nasana matter, similarly, it was also trafficking in persons for forced marriage purposes, for subsection 2, and then for 1, for sexual exploitation purposes, which would include rape, yet they were the 2 rape convictions.
Of course, one will have to look at the test,
Yes.
and the elements. That's why we went there. But there are also authorities who say it's not the end of the world.
My Lord,
Because at sentence stage,
Yes.
it becomes a different issue.
Of course.
But one has to test the facts against the elements of the offences, and if there's more than one, so be it.
Yes, my Lord, indeed. And going back to where I started this morning, creating good jurisprudence, developing the jurisprudence on the legislation. So
There's also, of course, the danger. If one wants to read in too much of the one into the other, supposing, because you're dealing with a statutory offence on count 1,
yes.
and the court is of the view, but it's in any event read in there, so I'm not going to bother with it now. And then the conviction can't stand on that. What do you do then? But I will go and have a look at the Act and I'll consider it.
Yes, my Lord, and if I may just by way of reiteration, the kidnapping is not included as one of the acts, the conducts. It's one of the means. It can be one of the how it is done, the second element of the offence. I still submit that in following the case law, it should be 2 separate offences and that it should be that way. My Lord, may I, in closing, just refer you to, and we don't have a defence case in this matter, but we do have the evidence of accused 1 and 2 during the trial within a trial. My Lord, as set out in my heads on page 40, I submit that accused number 1 was a very poor witness.
I've admitted the statements, right? Yes. And I will give brief reasons.
Thank you.
In the judgment. And the same apply for the 174 discharges.
Yes.
So the 174 may be less especially so far as it relates to accused number 2, Mr. Van Ryn, a little bit more maybe for Ms. Smith. But in the event that I acquit Ms. Smith, then it's of no moment.
Yes.
Right? It's only if I convict.
Yes.
Insofar as the credibility of the 2 accused that were part of the trials within the trials, you don't have to address me. I don't want to hear you on it. I would like to hear whether your colleagues have a firm view on their client's credibility.
Thank you, my Lord.
But I don't need to hear the state on it.
Thank you. Thank you,
Yeah.
my Lord. So in closing, may I then, if the court will allow me, 5 minutes and I'm done.
Yeah, sure. And then we'll take the lunch and adjournment. Then we'll kick off with Mr. Harmsa.
Please, my Lord.
And see how far we get.
I see it is 5 to, I promise I'll be done.
No, because we're going to take an adjournment then, say for half an hour. So we might not get to Ms. Nkabai today, because we also don't want to interrupt the argument. And then we'll kick off with her in the morning.
As the court pleases, my Lord. Just for then the inferences sought to be drawn, except for those that I have now in my address already referred the court to, but more formally, we request then that the court should in fact find that all 3 the accused, or accused number 3, actually planned this action from as early as August 2023, when she had this discussion with Mr. Kutsia. From that discussion, it's clear that she had already been disappointed. So it even dates back earlier than that, but at least from August 2023. That's when she had already started planning this. Secondly, that Joshlin was indeed sold, and that it was for the purpose of exploitation, the exploitation being in the form of slavery or practices similar to slavery. Thirdly, that there was indeed an agreement reached between the 3 accused and Ms. Lombard, that the agreement entailed that Joshlin will be sold and that they will keep quiet and tell no one anything about it, including the police, that there was a common purpose between them. There had been an agreement. And then fourthly, that all 3 the accused knew, or ought reasonably to have known, that Joshlin was in fact being sold for the purpose of exploitation. And lastly, that all 3 the accused and Ms. Lombard stood to benefit financially from this transaction. And once the court makes those inferences, I submit respectfully that a conviction should then follow in line with those inferences. So that is why the state prays for a conviction of all 3 the accused on the main count of trafficking in persons, and then on the kidnapping count as explained earlier. And then just lastly, my Lord, although I didn't deal with Laurentia's evidence specifically, it is dealt with in the heads, but I do submit from state side that if the court accepts her evidence to be credible, the court should make the ruling that she honestly and frankly open answer to all the questions, and that she should get the indemnity.
I specifically didn't ask you about that because I don't want to engage in that argument now.
All right.
Once I've made my factual findings and my findings on credibility and reliability, it's an issue that we will have to revisit.
Indeed.
In the event that I'm with you on your argument, as you've given me this morning, then clearly I don't have to engage further. But there might be a fine line where one finds on certain aspects, and then one will have to apply the test in the act, because it's not just about reliability and credibility.
No.
The test is something different.
Yes.
But once I've made my ruling and my finding, then we will deal with that.
Thank you, my lord. Then I rest. I have nothing further to submit.
Thank you. It's almost 1 o'clock, till 1:30. Half an hour break. Mr. Harmse, how long do you anticipate you're going to be?
My lord, I don't anticipate being very long, but the interaction could lengthen it a bit, my lord.
The interaction might shorten it. No, I just want to put your colleagues' mind at ease that you will take up the rest of this afternoon at least. We're not going to get to them.
My lord, I
Just
don't
so
think...
that they can relax, otherwise they're on edge. We might still be called this afternoon.
My lord, I cannot
Because
predict.
even if I'm an hour with you, it will take us to almost 3 o'clock. So we won't get to Mr. Nkabai and Mr. Sivnarain this afternoon. Yes, you bear no onus, so you can be quick. The court adjourned. Right, Mr. Armse. Thank you. I've got your heads of argument here.
I was just about to inquire, my lord. I was just about to inquire if your lordship
I have
found it.
I have it open on the side here, and I have Litako and others, Bulwana, Guadiso, Bueta, Molimi.
Lord, I'm not going to refer to all those.
And Murphy.
Yeah, I'm not going to refer to all the case law that I've passed through. It's not going to be referred to Malimi. Your Lordship would be aware that those matters are primarily concerned with the Law of Evidence Amendment Act and admissibility of extracurrial statements. I submit that that's not accused one my client Accomplice's problem at this stage. I just want to point your Lordship to my heads of argument, page 5. I see that I've neglected to fill in at paragraph 16 on page 5, page number there that refers to the state's heads of argument.
Yeah.
And that number should be 27, my lord. I apologize for that oversight.
It's not a problem. Page number 27.
27, my lord.
Yeah, you sent it in the PDF, so I can't amend it over there, but I've made a note.
I apologize about that.
No, it's fine.
When I get to that, I will refer to that. I am now at this point uncertain how I should approach my argument, in the sense that I have some important references to the state's argument. And I don't want to jump around, so maybe I should just start with my heads.
Yeah, and then you can deal with the state's
and deal
argument.
with these as what's not in my head. Yeah. Thank you, my lord. Lord, yes, the defence on behalf of accused one, Mr. Accomplice, is I submit, not very complicated. I start with my introduction basically just with the charges, and then I start with the state's case and refer to the summary of substantial facts by the state. Now, the high watermark, or the main gist of Mr. Accomplice's defence is, and that's the reason why I listed these very shortened, by myself, shortened summary of substantial facts in terms of section 140-43 of the state. I'm not going to read it, but your Lordship will notice that all these aspects referred to on my page 2, which is from the summary of facts of the state, all relates to evidence that the state was going to, that the state alleged that they are going to present to court. That is all in line with evidence that was presented by the 204 witness, Laurentia Lombard. Now I'm going to proceed referring to as the 204 witness, with the leave of the court. Everything there refers to what was evidenced by the 204 witness. And then in my paragraph 5, I state that the state summary of substantial facts undoubtedly accords only with the 204 witness version of what happened to Joshlin. And then it is submitted that although the 204 witness was in material respects largely discredited, her evidence cannot just be ignored or wished away. I concede that, my Lord, and I've heard the arguments and your Lordship's discussion with the state, interacting with the state. Yes, everything that the accused, that the 204 witness evidenced about cannot be said to have been untrue, but there are material contradictions. And the first one that comes to my mind now immediately is her evidence in terms of her confession, Exhibit R, and her 204 statement, and her evidence in chief. There's a contradiction, serious contradiction, material contradiction. And that was the discussion that she gave evidence about, the evidence that she gave about the discussion between accused 3 and accused 1 in the presence of accused 2 and the children. That on the one hand, she said that happened on Sunday when she was listening outside the window of accused 1 and 3's house. Then she was questioned, cross-examined, but then a later version, or a version in, I think it was in her Exhibit R, confession, she said this discussion took place on Monday morning. I submit that is a material conflict, discrepancy. Yes, but that I mention now, my Lord, and I can get back to that at the end, because we are looking, as your Lordship refers to a timeline. I don't really have a timeline here, other than the 204 witnesses' involvement. But I'll get to that. I just want to take your Lordship to my page 3 of the heads. Paragraph 7, I say that the state's evidence in the form of a 204 witness, which clearly represents a version or a set of facts to prove their case against the state, against the accused. That's the state's 204 witness. In her evidence, represents a version, a set of facts as to what had happened to Joshlin. The 204 witness in her evidence clearly attested to the fact that accused 3 had taken Joshlin to a polo on Monday, 19 February 2024, during lunchtime, and that accused 3 thereafter went back to work. In essence, both in the 204 witness's confession, which is Exhibit R, dated the 15th of March, and in her 204 statement, which is Exhibit X, dated 21 October 24, she evidenced that accused 3 took Joshlin to the polo while during lunchtime on Monday, the 19th of 2024. Now, there were discrepancies in her Exhibit X confession, which was somehow corrected by the state, and herself in evidence in chief, where at one stage it was said that accused 1 had walked with accused 3, which she later said no, that didn't happen. evidence as far as the discussion that she overheard on Sunday is clear, my lord, that she says that she heard accused 3 speaking to accused 1 about Joshlin, and that accused 1's attitude was, and I don't recall the exact words, that he is not interested, he doesn't want to listen to her stories. He doesn't want to listen to her stories. And then accused 3's attitude was, well, then I'll do it on my own. Now I submit that is a clear indication of accused 1's non-involvement and not acting in concert with accused 3 as far as that's concerned. According to the state's 204 witness. And then the 204 witness says in a confession and in her 204 statement that she said that accused 3 took Joshlin to the white polo during lunchtime on Monday, 19 February 2024. In short, that was her evidence. She, 204 witness said she got very early in the morning, around 7 o'clock, to accused 3 and 1's house. She overheard the discussion. There's where the contradiction between the two, the discussion about the money contradicts with the Sunday hearing it. And that accused 3 would then have packed a bag, spoke to accused 1, said she must keep Joshlin ready because somebody's coming to pick up Joshlin at 2 o'clock. In terms of accused, that the 204 witnesses' evidence, she says she witnessed accused 3 walking towards the polo, Joshlin and accused 3 getting in a polo and driving off. Then there was a contradiction as to whether she had seen accused 3 get out of the polo again or not. But in essence, the evidence was that accused 3 then, she didn't see her again until later. Accused 3 after that went to work after she had left Joshlin with the people in the polo. Now, leaving aside all the criticism of the 204's witnesses' evidence as to her ability to observe certain facts, observe certain people, the Sangoma, so-called Sangoma. First she said she could hear what they were saying, then she corrected it, she didn't hear what they were saying, then she said she saw it was money, but then later she had confessed that she admitted that it wasn't money that she thought that it was money. That was in the packet that the Q3 received. The position of accused 1 is that it is submitted that accused 1 was not part of, neither involved in the preparation or delivery of Joshlin in terms of the Section 204 witness on behalf of the state. Now, my Lord, that is a version that the state decided to present to this court. The problem that I submit that the state has is that a second version was placed before this court by way of the trial within a trial, when the so-called re-interviewing of the 3 accused took place at the sea border. Now, after the trial within a trial, this court found that the extracurricular statement of accused one was found to be admissible. Of importance, I submit, is that the fact that the state, by presenting the facts of how the extracurricular statements of accused one and accused two was obtained or procured, it undoubtedly associates itself with a version of events that the evidence suggests. Most importantly, the state hereby sought to present a set of facts as to how Joshlin would have been delivered to Makalima by accused one on instruction from accused three. And Lord, what I'm submitting there is that the state-led evidence opposed the application that, or the contention submissions by the, and evidence by the accused one, that the statement was not freely and voluntarily obtained, but this court found that it is admissible. So that's where we are. It was admissible. My point is that the state identified with that set of facts. Now, accused one, I submit, irrespective of the fact that he may be found to have been discredited in several respects, the effect thereof, it is humbly submitted, cannot wipe out or remove the fact that the material aspects of the extracurricular statement are denied by accused one. Now, that was accused one, whether he was a discredited and unreliable witness. His evidence in the trial within the trial was that he was not the author of that version. Now, I'm mindful, the court is very well aware, and so is the state, that there are certain aspects that's very questionable as to, and then the recanting by accused one of certain aspects that he said was true, and then he said it wasn't true. Yes, there's a lot of confusion there, my lord, but the bottom line of accused one version is that his version was, that he gave evidence about, is that he was told what to say. The material aspects that was was revealed, the material aspects, not everything, the material aspects. And the material aspects was that there was a conversation between accused one and accused three, that accused three would have told him what to do, the money involved, that he should take Joshlin to Makalima, and that is the material aspects, which he said it's not his vision. He didn't say that because that is not true in his version. Yes, he was discredited. So herewith is in essence referred to the denial that he was instructed by accused three. That was his evidence. He denied that he was instructed by the accused three to deliver Joshlin to Makalima, and he denied that he did deliver Joshlin to Makalima. That was just a story, he said. What should be borne in mind, my lord, is the fact that the state had already been well aware of the contents of accused one's extracurricular statement that was presented as a confession, but it was found by this court to be an extracurricular statement. Exhibit KK, as well as the warning statement by accused one, Exhibit MM. 10 days, these statements were made, the Exhibit MM warning statement was made on the 6th of March 2024, the Exhibit KK extracurricular statement was made on the 5th of March 2024. 10 days before the 204 witness made her confession before Captain Celia, the state was well aware there is a statement and what happened and what was written before the peace officer. They were aware of that. 10 days after that, the 204 witness made a confession before Captain Sulia. And 7 months later, the 204 statement was made before Captain Lombard, the IO. Now, it is admitted that it can be inferred, after having obtained the confession, in brackets, from accused 1 on 5 March, that the state did not really view the confession of accused 1 to be a true confession. I say that, my lord, because if the state was satisfied that that wasn't a story that the police had told the accused 1 and 2 to say, it was their own story that they really wanted to open up, why would they then go along with a version of the 204 witness? First, the confession, which is also contradictory to the version that was written in accused 1's confession, and then the long statement in terms of 204, of the 204 witness. So what I'm submitting is that the state does not really view the confession of accused to be a true confession. Now, my lord, I cannot revisit the freely and voluntary aspect. This court has made a ruling. The argument is that if the state viewed the confession of accused 1 to be a true confession, which was freely and voluntarily given, why obtain a 204 statement from a co-accused that contradicts the events or versions as stated by accused 1 in his statement? My lord, and here I submit that the two versions, the 204 statement evidence, the 204 witness evidence, and the extracurrial statement by accused 1 are two mutually exclusive versions. They can't both be true. I'm mindful of the fact that, yes, the concept, the principle, as had been discussed and offered by the state, that there was a concept that Joshlin would be sold, irrespective of to whom and in what manner. I submit that that is not as simple as that, my lord. I want to take your lordship now to paragraph 16 of my page 5, which specifically I refer to supporting my argument now.
Paragraph 16.
Page 20, my paragraph 16, page 27 of the state's heads of argument. It comes from, and my printer probably printed it differently. I don't know if it's on. I think I've got the right page number, page 27 of the state's head of argument. It falls under the category of his testimony continued after the completion of the trial within trial, and his testimony refers to Captain Lombard.
Yeah.
On mine, page 27 on top, the very first 3 lines, it says, and this is the state that says, he, and that's Captain Lombard, was asked in cross-examination for his view on the fact that the accused implicated Pumza Sigara.
Page 27 of the state's heads. My page 27,
if it's
top of the page has something else.
Then it must be lower down.
I know what you're referring to, but...
What? What I'm referring to is...
No,
is two,
I recall what...
it's two paragraphs above 3.20, Colonel Morris, my lord.
Two paragraphs?
Above.
Above that. So that's on 20... Yeah, it's on 26.
I apologize for that, my lord.
On my printed 26.
I've realized after I printed it, my lord.
And it's underlined. Is that the portion that's underlined?
It's underlined, my lord. And it says, if I may read it again, he, and that is Captain Lomard, was asked in cross-examination for his view on the fact that the accused implicated Bumza Sigaga, that's Makalima, my lord, in the extracurrial statements, full stop. His answer is that the story of Makalima is a forefront that was used by accused 1 and 2 to protect the truth or to cover the truth. My lord, to me, if the state argues this, states this, it supports my argument that they didn't believe that the accused one's confession, so-called confession, was the truth. Which, my lord, with respect, I think leaves me with the question, but then why was there a trial within a trial? If the state didn't believe what was said there was true. My paragraph 17, I say, the meaning of the forementioned shall be questioned in court during argument. I have done that, my lord. The above is true. Why was a trial conducted or held? To present a story which the state didn't accept. From the beginning, they thought, and it's argued by the state, that it's as a forefront, used by accused 1 and 2 to protect the truth or to cover the truth, the exact words. I submit then that the question that begs an answer is, should it not or could it not be inferred that there is no other reasonable explanation other than the state did not view the confession of accused 1? And I wrote this, my lord, before I entered my paragraph 17. The state did not view the confession of accused 1 as complying with the requirements of section 17 of the Criminal Procedure Act, which is confessions, and then elected to base their case on the version evidenced by the 204 witness. And then I go on, paragraph 19, I say that this court, having found that the so-called confession of accused 1 may be admitted into evidence, I submit to suspect did not find or rule that the statement was indeed a confession, nor that it was an admission. It was merely referred to as an extracurrial statement by this honourable court.
So what?
I'm just confirming it.
But so what?
My lord, it doesn't have much. It has an effect on accused 1.
You see, the inquiry that I had to undertake at the time was not to rule whether they were confessions or admissions. I merely had to rule whether they were admissible.
Yes, Your Honor.
And I made it clear in the ruling that I am not going to say anything about whether they were admissions or confessions.
Yes.
And it goes beyond the mere question of a court pronouncing whether a document is a confession, particularly a confession, because what you're then saying is, this amounts to a statement that has the equivalence of a guilty plea. And it's premature, because there might be a lot more evidence to be led. It might also be that in the defense case, there may be issues. It was obviously up to the defense to present evidence if they so wish. They decided not to. That's their choice. Similarly, as it is the prerogative of the state to decide who they're going to prosecute, what they're going to prosecute them for, what evidence they're going to present to the court, and it's then for the court to determine what factual findings I make. You pose the question and say that they didn't believe, I will make that call when I evaluate the evidence. We were all in this courtroom. So yes, and I'm still not going in argument now say what I believe these statements are. Because this is argument stage. It's not a place where you make findings or rulings. Make findings and rulings in the judgment, which I will do. And what often happens, Mr. Harmse, is that somewhere between versions, the truth lies somewhere in the middle. Now, I've been patient with your argument because I read the heads. Came in last night. The debate here, and you've made the point that the state didn't believe the version and now they want to get on the back of the statement to try and get a conviction. That's something I'll have to consider. Now, unlike a reply to a request for further particulars, in a case where the state had filed a formal reply, last time I checked, the jurisprudence is that the state is bound to the pleading. I'm not so sure a 144, section 144 summary, what the weight of that is. I don't know whether you found any authorities to say that the state can't now present other evidence. Might relate to...
No, certainly didn't, my Lord. I'm also not submitting that the case, that the state is bound by that. I'm merely arguing that it is very clear what the state's intention was and what was presented to the accused as to which case needs to be met. I just want to get off, if I may, off this point and just finalize my paragraph 20, where I say that in essence it is submitted that the accused one's executable statement is only proof of the existence thereof, not that it is the truth. The accused one has not admitted that what was said there was the truth, except for certain of the, as he termed it, he wanted to make a story. Some of it was true. He was completely discredited under cross-examination. But what I'm submitting is that confession or extracurricular statement being admitted proves that it was made, but not that what's written in there is the truth.
It was admitted into evidence.
It was admitted into evidence, and the probative value thereof, obviously, the court has to decide. Then I just want to refer the court to incorrect statements in the state's heads of argument, other incorrect statements. It's not much is going to turn on this, my lord, but as the English has a saying, look after the pennies of pounds or look after themselves, my lord. There are a couple of misstatements by the state in their heads of argument, and one of them, the first one is that I picked up, is on page 11, and again, I think, again, I think there might be a page difference. I think when I first saw it,
I know exactly
it was page 11.
I know exactly what you refer to, but it's of no moment. Remember, the evidence goes slightly further than how it's stated in the state's heads. On the discussion on the Sunday, it may be interpreted that he wasn't willing to go along with the plan in any event, if it happened, because your version, that's not before the court but put to the witnesses, was it never happened because you said it doesn't have time for this nonsense of yours.
Yes, my lord. I just
and she never stopped the. She said in the confession she attempted to stop, but Ms. Smith didn't want to listen to her.
Yeah, and then
and similarly, that can be. It can be argued that his comment on the Sunday meant the same. It can be argued that way. But of course he didn't come and tell us.
No, my lord, but my point is that the state is specifically saying that the 204 witness, Laurentia Lombard's evidence is summarized. It is stated that although she, Laurentia Lombard, tried to stop accused 3, accused 1 never tried. That's what the state says. But in the confession, the 204 witness deposed to the fact when she was asked, why didn't you stop her? That's accused 3. Laurentia Lombard said, I tried in English, I tried to stop her, but she wouldn't listen. She wouldn't even listen to the state question, answers the question, she wouldn't even listen to Bhutta. So this is not correct. I just wanted to point that out, my lord. Then I want to just lightly touch on to inferences, my lord.
We're going to go there. I want us to...
State's argument is on page 6, paragraph 6, page 48. State argues that certain inferences be drawn by this court.
That reference of Tom, where did you get that reference from?
Sorry, my lord, I can't hear.
The reference to Tom.
Tom versus S.
Yeah, but where did you get that reference from? Because it's wrong.
It is, unless I typed it incorrectly, I've got Tom versus S in brackets CA01.
No, the reference is wrong. The judgment was given on the 29th of November 2022.
Yes.
And you see, the reference that I have is different. This was it was a full court judgment. It was a full court judgment. You say Van Zyl DJP,
Yes, my lord.
Malusi concurring. But there were 3 judges in that matter. Also, it shows, it looks as if it shows, from your reference, it says GHC. Now, I don't know where you got your reference from.
I have the matter in my hand. I have this matter in my hand.
Yeah, but where did you get it from?
From Safley.
Because I've got Safley, the Safley one open here now.
I got it from Safley.
Did you've got the just show it to me from where you are. Okay, so that's the Word copy or the PDF copy, right? Because it's got the logo.
That's a PDF copy, isn't it?
Now the Safley reference on Safley, that GHC is the old reference to Grahamstown High Court. Then he changed to MKHC, which is Makanda. My reference says page 98. Your reference says 89. And the third judge that's not referred to is Judge Lang.
It is referred to here, my lord.
Yeah, no, I'm looking at the heads. In the heads, there's no...
Yes, my lord. I noticed that I've not put in Lang, Judges Lang, it's Malusi.
Right.
And I neglected to put in Lang.
And merely what's quoted in the heads, it's nothing but a restatement of the principles in Rex versus Blom.
Correct, my lord. Yeah.
Which is also known as the cardinal rules of logic. Now I just mention it because when I looked at the case, I obviously opened it up from source. I know it was there. So the one that you have in your hand doesn't have, I'm looking at the one that you have in your hand. That's the PDF. It doesn't have that reference. Now, it's also reported in the South African Criminal Law Reports 2023 volume 2 at page 283. What does it help Mr. Harms to quote me a recent case that merely quote within the quote from Rex versus Blom 1939 AD, page 188, and I've highlighted the 2 pages to... What about the later decisions of higher courts?
Lord, I have the greatest respect for the Deputy Judge President, Dion van Zyl, and when I came across this matter, and I thought, well,
I've got no problem. I've got no problem with it. I've got no problem with you referring me to the case. All I'm asking is, does it help to quote to me Rex versus Blom? It's trite. It's an established principle. I don't know whether it's still in the textbooks. I don't know who still refer to it besides the magistrates' courts. Because there are specific Supreme Court of Appeal decisions, recent and not so recent. The Reddy one was in 2016, I think it was, and the other cases are there. So I take note of it just for purposes of whoever quotes this case, so that the reference is correct. I'm definitely not going to refer to it in my judgment, because there are stronger authorities on the point. If I quote any cases, I'm going to quote cases of the Supreme Court of Appeal.
I take note, my Lord.
But that's fine. So you're going to take me to what the other professors are saying.
There's a further reference, my Lord, by the Judge van Zyl.
Where?
Sorry, I see. I didn't include it in my head.
No, but I've got the judgment open in front of me. So if you take me to the paragraph number.
Ramalong. I'm now referring to paragraph 9, which is.
The one above
quite a long paragraph,
were.
but the reference in this matter is to R versus Mthembu.
Mthembu, yeah.
Which is a 1950 matter.
Which is also a very old matter.
Very old matter. And there what is quoted there is circumstantial evidence.
No, I'm aware, and it takes us to some of, in Mthembu, it takes us to some of the old authorities
Yes.
that you and I might still be aware of. It was even long before our lifetime, where the authority was Wigmore on evidence. So it still quotes Wigmore. But the facts of this case also, of Tom.
It's DNA matters.
It's the appellant is linked with DNA and raises an alibi. It's a bit different, but yeah, you decided that I have to read it, so I did. But yes, yep, I'm listening.
Further on my head, my Lord, I then deal in paragraph 26 with the accused one's election to not give evidence in the main trial. My Lord, that's very short, that I deal with that very short.
No, you refer to the work of
Swickard, presumption of
a
innocence.
law professor, where you express an opinion. But what about what the Constitutional Court says? Why must I have regard to what the law professor tells me, if the Constitutional Court has pronounced on it, shouldn't one first turn to the authorities of the courts? And yes, when did Swickard wrote what he wrote? When did Swickard write that article?
1999.
Right. And who was he referring to? Which cases was he analyzing at the time? When he formed that opinion, which cases was he analyzing?
I do not recall that, my lord.
You see, Swickard writes in his book and express an opinion on his understanding of the law. And I'm not criticizing him, the author, because he's an authority one can refer to. There's no problem with that. That publication is in 1999. In 2001, the Constitutional Court, it was late 2000, but it was published in 2001. The Constitutional Court had pronounced on the issue. And of course, before that, so in the Busa case, the DP, as he then was, referred to another judgment of Madala J. Constitutional Court pronounces in the Busa case on that issue. But I don't get taken to the Busa case by the defense. I get taken to a textbook. I get taken to the Witwatersrand, as it then was. Now the Gauteng High Court, so that was the Johannesburg Court in Van der Meyden. And I get taken to what these authors are saying in this textbook about what the court said in 1932 in Mokoena.
But I'm also, sorry, my lord, but I'm also taking your lordship to the S versus V matter.
No, you've taken me to S versus V.
It's also a 2000 matter, my lord,
Yeah,
1 year earlier.
That deals with the reasonable possibility whether the evidence of an accused is reasonably possibly true. The portion that you quoted.
Yes, yes.
Right. But and how the probabilities are taken into account to determine the question whether the accused version is reasonably possibly true. There is no version of the accused here. The first paragraph under that heading deals with the textbook of Professor Swickard. Then I get taken to the Van der Meyden issue, the Van der Meyden case, that also deals with the test reasonable, possibly true. Then I get taken to V, that deals with that. And then I get taken to the toy on the commentary that's given on section 208. We started out with the constitutional right to remain silent in paragraph 26. And that's why I'm saying, don't take me to Schwickard, take me to Bramfontein. Now we pass that. And then we jump to these other cases. And yes, if there's evidence, and what's good for the goose is good for the gander. So if it's the state's evidence or the accused evidence, on the accused evidence is to determine whether it's reasonably possibly true. On the state's evidence, whether it can provide proof beyond a reasonable doubt. The Supreme Court of Appeals said that it is perfectly, I'm putting in the word perfectly, right? It's perfectly permissible to look at the probabilities to determine the question. And that's what the debate that I've had with Ms. Swanepoel this morning. Now, there is no version of Mr. Apollos before the court. I can, however, still take into account the probabilities in testing the content of that statement that he made. But it's got nothing to do with the right to remain silent.
But my Lord, I submit there is a version by accused one before the court, which is in the which statement was provided in the trial.
Yeah, but in the same breath, you're telling me there's a version, but he also disavowed himself of it in the trial within a trial. So I must either say, okay, that version, I'm going to test it because it's there, that's the state's case. Or I must go with you and say, well, disavowed him of it. Now just go look at Rens. Rens was a bad witness, therefore give me the keys to the gate. I'm sorry about the mask, but I don't want to cough because the dust irritated me earlier, and I want us to push. Are you following my response, Mr. Arams? I don't know whether it makes sense to you. So you look confused. Am I confusing you?
I can't hear what your Lord
Am I confusing you?
No, my Lord, you're not confusing me, my Lord. No, no.
Because sometimes I have the habit of confusing myself.
No, I'm not confused, my Lord. I'm not at all confused.
So you want to move on? Because this is the end of the argument.
As I said when I started, the high watermark of accused one's argument is that the state has presented two versions to this court. And I submit that, as I've said, there are two mutually exclusive versions. Now, I could not find any case law where, in a criminal matter, the state had presented two versions, mutually exclusive. I know there are case law where the state and the defense has mutually exclusive or destructive versions. But I couldn't find any case law where the state has given, maybe because that doesn't happen often. As my learned colleague has stated in her heads, this is a unique case, a very unique case. And my submission to this court is that this is why I went to the probabilities, this is why I went to S versus Van der Meiden. All the evidence must be taken in consideration. But I submit that this, for a court to find that any one of these two versions is true, what if one takes all the evidence in consideration? How can one of those versions pertaining to accused 1 be elevated to proof beyond reasonable doubt? My Lord, because it would mean that other evidence that was presented is just totally ignored. Well, then there are from the state's submissions and in the arguments, a couple of misstatements again that I've picked up now that was stated. I don't think it'll take the defence's case any further. It is a small inconsistency, such as where it's stated by the state that accused 1 had said that the children, Requin and Joshlin, didn't go to school. Captain Lombard said accused 1 told him that they were sick. They were sick. Then it's referred to as, but in accused 1's plea agreement and in his statement, Exhibit M, he clearly said that the story about the dirty clothes. Story about the dirty clothes.
But we went there this morning, but we can go there again.
No, we don't need to go there, my Lord. I just wanted to
we can go there again. No. You're saying it's a misstatement.
I just wanted to refer.
So let's go there, right?
I just wanted to refer to.
I'm going to read to you.
Carry on.
On Monday, I'm reading from Exhibit M. On Monday, 2024/02/19 at about 8:45, I was at my house at the above-mentioned address. At that time, my girlfriend, it's spelled Rachel, Rachel, Smith, left to go to work. At home with me was her children, Requin Smith, aged 9, and Joshlin Smith, aged 6. Neither of the 2 children went to school that day. Joshlin had a cold. That was the Exhibit M that was made to Sergeant Milstein on the 20th of February, 1350, 10 to 2. So happens it's the same time that Ms. Smith said in her first statement that she returned home on the 19th. It's a coincidence, nothing to be read in it. So up to the 25th, this story was peddled. And yes, I know what's in the plea explanation, but that's not evidence before the court.
No, it isn't.
And then the one-pager made the previous evening or early hours of the morning doesn't say, give all the details. Interestingly, if one has to go and dig deep into it. But turning to her statement, to totally different officers the previous evening, she didn't say that Joshlin had a cold. She said Joshlin was not feeling well. And that changed later on to school clothes were dirty.
My Lord, yeah, I'm not arguing about on behalf of accused 3.
No, I'm just saying, so your client was also going with that same story.
My client said that it was the clothes.
It was a cold.
The clothes.
The last time I checked, clothes are spelled C-L-O-T-H-E-S.
In Exhibit M, my Lord.
In Exhibit M, there is no clothes, it's C-O-L-D. Now, English is not my first language. I'm referring you to paragraph 2, last line, under the 3 that's circled. Where the clothes are mentioned is in a separate context. And it doesn't say school clothes either. Because he says he's now discussing the whole thing about what happened on the day. Because he now saying that Kelly came home for lunch. And it was that time that he was washing the clothes, although he puts it at 11 o'clock. But we can have fun in going into the contradictory versions that the accused had given extracurrially. But it's of no moment because they didn't come and testify. They didn't challenge the state's evidence.
I can't recall, my Lord.
And that was their choice. Yes, Mr. Adams, I'm waiting.
If there's nothing else, then no.
Okay. Thank you. Ms. Nkabayi, it doesn't make sense to start with you unless if you're going to finish it within 23 minutes. In the morning, rather. Rather start in the morning. You're rather going to start tomorrow morning. Now, I know that we will adjourn slightly earlier, but it doesn't make sense. I don't want to interrupt counsel's argument. And we had a long day from this morning, so let's rather do the sensible thing. I'm going to start at 8:30 tomorrow morning, and I am going to finish the argument, both Mr. Nkabayi and Mr. Sievenarijn, tomorrow. Otherwise, I won't be able to give the judgment on Friday, so that I can work through. Your updated mind map, you can send it to everybody so that we have it. We'll upload it on Teams. And we'll deal with that. Ms. Nkabayi, just before you go, have a word with my registrar. Before you go this afternoon, have a word with my registrar. You've given her a stick with the authorities that you're going to refer to. She couldn't upload it at the time when I saw her during the lunch break because it wasn't downloaded on the stick. But if you have it on your laptop, then you might quickly be able to arrange it so that I will have it tonight. Means I can read through it. Any authorities. There are no heads from you as far as I know.
I do have them, my Lord.
Can I just have the heads as well? Can you send it to me through Ms. Naidu Chetty? So that I can prepare. I have Mr. Sievenarijn's heads and I have your authorities. I saw it uploaded. I didn't read it yet. Mr. Sievenarijn, your heads are in. Is it just the authorities? You're not going to draft heads?
I have not drafted.
Are you going to? You don't have to. You don't have to draft deeds. As long as I have the authorities, I'm fine. But if there are heads, then it will help, but we don't have a lot of time. You complaining?
I'm not complaining. My apologies. It's merely a request. Is it possible for us to ask also to receive copies of the heads?
Absolutely.
We were given these heads now before Mr. Harmse started. We don't have the heads. We don't have the
If the defense have heads of argument, please let the state have it as well. And did you receive the list of authorities?
Nothing, my lord.
So,
nothing.
Whatever comes to my registrar gets uploaded. So if you go to that tile, you will find it. So all the authorities that Mr. Harms sent yesterday, although in some instances he just gave the names, she actually searched it herself and placed it on the platform. Mr. Sivnarayan's authorities are also on there, and yours came through yesterday during the course of the morning, and they were all uploaded. That's the way I accessed it. I accessed it on my phone yesterday. So it's quite easy. Let us work with each other, see how we can make things work better. Mr. Pollis, Mr. Van Rijn, you're going back to Malmesbury. Ms. Smith, you will recall that on Thursday when we adjourned, I said I'm going to make the decision after I've consulted with the police, and that's why you went back to Langebaan. Because having considered all the issues, I was not satisfied that Paulsmoor was going to work. And that's why I sent you back to Langebaan for the weekend, and you will go back there again today. 8:30 tomorrow morning, when we will, hopefully we can, if we have Mr. Harms, it took an hour, I think, less. If we can say hour and a half max, 3 hours, we can be out here early. I can go and work, and I can come back on Friday morning. Don't expect a written judgment. It's going to be an extempore. But the recording will be available immediately thereafter. I'm not going to type a judgment. I won't have time. Thank you, warrant. I haven't signed the warrants. I'll do that for you now. Court adjourned.